Good morning, everyone, and welcome to the 26th meeting of the Justice Committee. We have no apologies today. Our first item of business is to agree to take item 6 in private. If members are not agreed, could they indicate in the chat function now? No member has indicated that they disagree, so we'll take that item in private. Our second item is to continue our consideration of the Hate Crime and Public Order Scotland Bill at stage 1. And we have before us today two panels of witness, and I welcome now our first panel, Roddy Dunlop, QC, the Dean of the Faculty of Advocates, Michael Clancy, the Director of Law Reform at the Law Society of Scotland, and Dr. Andrew Tickell, who is a lecturer in law at Glasgow Caledonian University. And I'd like to thank all the witnesses for their written submissions, which are, as always, available on the committee's web pages. And because we've got a lot of witnesses this morning and a lot of issues, I'm going to go straight to questions and not invite you to make opening statements, also because of the length and detail of your written submissions, which have been extremely helpful. And I'm going to launch straight in, if I may, and first to Roddy Dunlop, to reflect on the proposed amendments that the Cabinet Secretary Humza Yousaf has indicated that he wishes to make to Part 2 of this bill. Given the tenor of the written evidence from all of the witnesses this morning, it's obvious that the witnesses will welcome those amendments. But my question is whether those amendments go far enough to ensure that the bill does all it needs to do to protect fundamental rights of free speech, privacy, and the right to a fair trial. That question to Roddy Dunlop first, please.
Yes, I'm much obliged for hearing the views of faculty today. It is absolutely correct to say that the proposed amendment is welcome and indeed has been welcomed explicitly by faculty. It addresses a number of the concerns because as you work through the faculty submission, you will see that a recurring theme was the potential damage that might be done by the likely to stir up provision allowing for unintentional criminalisation in an area where that would not be welcome. And that does address many, not all, but many of the concerns. I say not all because we do still have a residual concern regarding the use of insulting with regard to race and only to race. And that really for the reasons already discussed in the submission and under reference to what was said by Lord Brackadale. I mean, ultimately, if we look, the answer to that has been given already, will be given again, no doubt, by those who propose it, to say, well, this has been on the statute book with regard to race since 1986. What's the problem? The problem I have with it is that it is very difficult to see what it adds, because if we look at the 20-year history that statutory provision has, I certainly have been unable to find any prosecution which even suggested, let alone ultimately turned on insulting as being the crucial provision. It is very difficult to see a situation where words are used that are not threatening, that are not abusive, and yet still might be thought worthy of criminalisation under reference to the insulting provisions. Really there are two aspects to that. The first is why would one interest to be protected against insult? And secondly, but more importantly, is that insult is seems to me you very much bring in subjective concerns. All sorts of people are capable of being insulted by all sorts of things. Whereas when you're looking at threatening, something is either threatening or it's not. That's quintessentially objective. Something's either abusive or it's not. That's quintessentially objective. When you get into notions of insult, you very much move into the notion of subjective. And there is the concern, first of all, that might criminalise material that really shouldn't be criminalised. And secondly, that even if that's not the ultimate result, because, for example, you still have the check on, is it really with an intention of stirring up hatred, that you might have the prosecution of people or people being or demanding these prosecutions because they personally have felt insulted by something that's been said. And in a world where we are told repeatedly under reference to the convention, and appropriately, it seems to me, that a pluralist society must be open to notions which are not only those that are welcome, but also notions that are liable to offend, to shock or disturb. I struggle with a provision that allows the criminalisation of something that is merely insulting, and I say merely because, as I say, if it's also threatening or if it's also abusive, it will be struck at. And just finally on that issue, I do suggest that the case of Faber and Hungary, which we cite in the submission, is of some import in this regard. And that was the case where there had been the flying of an offensive flag close to an anti-racism demonstration. And it was accepted that the use of that flag would cause unease and a sense of disrespect amongst past victims. Now, that seems to me to be pretty close to something that would be deemed to be insulting, but only insulting. And the European Court of Human Rights found that that was a violation of Article 10 because there was nothing violent in it. Therefore, there was no threatening aspect, there was no abusive aspect in it. And I do struggle to square away the guidance in that authority with what's being suggested on insulting only. So that would be the primary residual concern that we have with regard to the legislation.
Thank you very much. I have a couple of follow-up questions on that, but I'd like to bring in Michael Clancy first, please, on the same question I asked Mr. Dunlop, and also to reflect on what Mr. Dunlop has just said. Michael Clancy.
Thank you very much, Convener. Good morning, everyone. We at the Law Society agree with the Dean's assessment of the Cabinet Secretary's amendments. We've taken a look at those, and they do relieve a lot of our anxiety about the provision in Section 3 and Section 5. But I think there are issues about the use of the word insulting. As the Dean has pointed out, this is a subjective test, and in our submission to the committee, we noted that this was lowering the bar for criminality a bit too far. Not only is it a subjective test, but of course, with the introduction of the new crimes in the bill, we feel that it might create some kind of hierarchy between the stirring up hatred on the basis of race and stirring up hatred on the basis of the other characteristics. So those points, I think, are quite important to take into account. You asked about freedom of expression, Convener, and of course, freedom of expression under the Article 10 of the European Convention on Human Rights is not an absolute right. It has to be tempered, and if I could quote from the article, that everyone has a right to freedom of expression, but the exercise of this freedom carries with it duties and responsibilities and can be limited as by way of prescriptions of law and as are necessary in a democratic society and for the prevention of disorder or crime. So it's quite clear that it is perfectly legal under the terms of Article 10 to seek to control freedom of expression. It's a question of how far one goes, and perhaps the word insulting is a word too far.
Well, thank you very much, Mr. Clancy. And again, the same question, please, to Dr. Tickell, and also the invitation to react to and respond to what you've just heard, Andrew, from Roddy Dunlop and Michael Clancy. Andrew Tickell.
Yes, well, thank you very much for the invitation. It's very welcome, I think, to see the Scottish Parliament really anxiously scrutinising a measure in terms of free expression. I think that's not something the Parliament has always done, and as Lord Brackadale himself recognised when he made his recommendations, stirring up offences inevitably raise questions of free expression. I think in terms of the Cabinet Secretary's amendments, I very much welcome the shift towards an intention form of mens rea, which I argued for in my submission along with others. I think that many of the free speech anxieties, some of them are well-founded and some of them are exaggerated and excessive in respect of this bill. And I think in terms of moving to an intention-only model, then that should very substantially allay the anxieties that people, I think, rightly had about the first iteration of this legislation. And we shouldn't just jump over the idea of intentionally proving an intention to stir up hatred as if it's a small thing to establish. It shouldn't be a too difficult thing for prosecutors to establish, but it's no small requirement. You know, there's an awful lot of, I think, misinformed and exaggerated discussion around this bill, and I think we really need to be quite careful about taking seriously the terms of these new offences. So I think that shift is an extremely welcome one. In terms of issues around insulting, I tend to agree with Roddy Dunlop's propositions there. I don't think the argument it's in the Public Order Act, therefore it should be in this bill, is convincing really for any of the arguments around that. I think we should look at it from a first principles type perspective of whether these protections or restrictions or extensions are necessary. Personally, I struggle to see circumstances where communication or comment would be somehow insulting but not abusive. I mean, abusive is a pretty capacious concept as well. So I think in terms of the consolidation principle that's notionally undergirding this bill, it would be a good idea to make this just more simple. I don't see really what it adds in terms of the protection. And if there is anxieties about perceiving to make it harder to criminalise people who do engage in racial incitement, well, I think that can be addressed, you know, by those types of arguments. In terms of free expression, as I argued in my submission, I think there is scope to allay anxieties, if you like. I mean, as has been commented, this bill is subject to the European Convention on Human Rights, as would any enforcement in court. The court is subject to that and would have to consider in convicting or not convicting any individual whether the convention rights are engaged here. However, I think the extent of the anxiety around this legislation means that although the reasonableness defence is welcome, there is perhaps scope to make more clear and to communicate more clearly, almost as a political goal as much as a legal one, that there are particular factors which should be taken into account in terms of these stirring up offences, of whether or not behaviour should be regarded by the court as reasonable or not. So that would be, I think, my main reaction in terms of this element of the bill.
Thank you very much. That's very helpful. I've got 2 or 3 follow-up questions on the basis of what the committee has just heard. I think the first is probably, again, for Roddy Dunlop in the first instance. And the suggestion made, Mr. Dunlop, was that threatening and abusive are objective tests, whereas insulting is a subjective one. And I just want to ensure that abusive in this bill really is as objective a test as it is elsewhere in Scots law. So where threatening and abusive is used elsewhere in Scots law, there's a requirement that the abuse causes a reasonable person fear or alarm or distress. There's no such requirement in this bill. So is there not a danger that even though abusive is an objective test elsewhere in Scots criminal law, in this bill as currently drafted, it could elide into that subjective space that we perhaps don't want the criminal law to get into, and that the cure, if that is a problem, would be an amendment that would require that for the test of abusive to be met in this bill, it would require the Crown to show that a reasonable person was caused fear, alarm, or distress.
For myself, I couldn't have any objection, wouldn't have any objection to that sort of amendment. My only query would be whether it's necessary. I mean, you're quite right to say that in many contexts there is an express provision making that clear. But for myself, the word abusive, which is an ordinary word in English language, an objectivity to it that one doesn't have in insulting. And it's very difficult for someone to say, I subjectively felt I was abused by a behaviour which is not on any ordinary definition of the word abusive. So it seems to me that word already imports an objective test. But if there is any doubt about it, and it doesn't seem to me that the objective behind the bill has anything other than an objective notion, then there couldn't be any objection to an amendment to make that politically clear.
Yeah, I think my concern is less that we're going to see people convicted on the basis of something which is alleged to be but not really abusive. My concern is much more, and this is a concern that I frankly obtained from reading your written evidence that that police powers are going to be used to search people's homes and private premises for possession of a material which is said to be inflammatory, said to be abusive, but which it would not cause a reasonable person fear, alarm, or distress. That it's the use. When in my opening question, I did talk about freedom of expression, but I didn't only talk about freedom of expression. I also talked about the fundamental human rights of respect for privacy and the Article 6 concerns about due process. So, is there not a concern that allowing abusive to have a potentially subjective interpretation in this legislation would generate Article 8 and Article 6 considerations?
If there is any possibility of that, then yes, I agree. That is not my reading of the word abusive. But if there is any realistic possibility that it might be given that meaning, then I would strongly agree that it be corrected, or it be at least clarified by way of an amendment to the legislation to make that crystal clear, because that cannot possibly be what's intended. And I would share conveners' concerns as to the repercussions if that were to be the case. Frankly, that those very concerns are what leads me to rail against the retention of the insulting provisions that we've already discussed.
Thank you. Can I just ask Andrew Tickell and then Michael Clancy to reflect on the same issue? Andrew.
Yes, I mean, I suppose it's important that we do underscore, as is implicit in your question, convener, that the idea of threatening or abusive behaviour has been a crime in Scotland for 10 years. And I think it's interesting that a lot of the response to this bill sort of presupposes that that isn't the case. And that maybe tells us something about public legal education as much as everything else. As you say, you do need to establish fear or alarm. You don't need to establish distress for a Section 38 prosecution. It's simply fear or alarm. I think given the fact that Section 38 of the 2010 Act is on the statute books, we do need to think about this bill in the context of what's already criminal. And I suppose I would ask, if we did do what you suggested, convener, then what's the point of this bill at all? Because ultimately you would have an offence which required all of the same behaviour, and on top of that an intention to stir up hatred. Now maybe in terms of fair labelling and properly calling out particular types of behaviour, as Lord Brackadale said last week, which aims at a whole group rather than targeting individuals, maybe there would be an argument for that. But I think you would get into the territory of really removing whatever distinctive contribution is made to Scots law by recognising these stirring up offences.
Thank you. Same question to Mr. Clancy, please.
Thank you, convener. Yeah, it's an interesting proposition that we would change the bill in the way you suggest. I suppose one has to read the statute book as a whole. That would be one answer which I could offer. And so therefore, where abuse is defined in other contexts in the law, there might be some kind of indication to those who are prosecuting, those who are defending, and those who are judging that abuse might be, or abusive behaviour might be considered in that context. But of course, I suppose if we leave this bill without any specific definition, there might be a question as to why there is no definition of abusive behaviour in this bill, whereas there is in other legislation. And relying on the ordinary English language usage of the word abuse takes us so far, but it does raise questions, and it would be neater, particularly in the concept of some form of consolidation of our law, if there were a definition of that provision in this bill.
Thank you very much. I just want to move on to one final issue before I bring in first Liam Kerr, who wants to ask a supplementary, and then Liam MacArthur. And my final question is picking up directly on an issue which we explored last week with the Cabinet Secretary and with Lord Brackadale, and that is the possibility under this bill of what have historically been understood to be public order offences being committed now in private. And in the Public Order Act 1986, there is it's not quite a defence. It's a part of the constitution of the offence that the offence of stirring up racial hatred cannot be committed by a person inside a private dwelling. There's no equivalent provision in the bill as it stands. Is that an omission which is justified, or is it an omission which should be rectified? Mr. Dunlop first, please.
There's obviously been an awful lot of media coverage about this issue in the last week, and a lot of very strongly held views. You'll have noted it's not a matter that faculty picked up in its submission, and I see the position as quite finely balanced, because on the one hand, for the state to step into the home and interfere with freedom of expression in the home does seem rather draconian. On the other hand, as I think Dr. Tickell has pointed out himself, there are many instances in which the state does just that. It is equally criminal to punch somebody in your own home as it is on the street. And I suppose the countervailing view would be, well, you want to stop, for example, the radicalisation of children within the home by hate speech being propagated within the home in the same way as you do someone on a soapbox on a street corner. So I see the matter as quite finely balanced, and the primary concern I would have would be that it is abused, and that it becomes a situation where, as again has been suggested in the media, one's least favourite uncle becomes the subject of a complaint to the police because of what he said over the Christmas turkey. That can't really be what we're looking at here. But equally, should it be the case that you're able to breed hatred within the home without repercussion? I think that's more difficult to say that should be allowed, given the pernicious effects of hate speech and the laudable aims behind the bill, which I would remind the committee, the faculty is supportive of.
Thank you. It just might be, therefore, that we'd want to take the words "and public order" away from the short title of the bill, if it's not a bill that contains offences against public order. Michael Clancy and Andrew Tickell on the same issue, please. Michael first.
Thank you, Convener. It is something which the Law Society of Scotland's Criminal Law Committee didn't raise in its submission, and for what they're worth, my words here are without the sanction of the committee. So I think one has to think about where the state does intervene in the home. And of course, we've seen quite recently instances where the state has done exactly that under coronavirus legislation, where there has been a threat to public health and a contravention of the regulations, where people have invited 50 people or such into their home. So what is public order in these circumstances? Is it public order in terms of a number of people? Does the number depend on the size of one's family? The Dean's citation of a Christmas dinner table depends on the size of your table. But if you invite more people in and you make some kind of comments or allow comments to be made, I suppose, which would contravene this legislation, then I think there doesn't seem to be, to me, a particularly hard line here about whether it is public order in the public space or public order in the private space. And so therefore, I think I would edge towards looking at this by including statements which were made in the home for some of the reasons which the Dean mentioned about the extent of criminal law and how it works. There is no sanctuary in that sense for most aspects of the criminal law, and I don't think there should be a sanctuary when it comes to hate speech.
Okay, thank you. And Andrew Tickell, please.
Yes, I mean, I suppose it's worth remembering, I know this is an irritable point to be making, but this is a bill about a regular form of street harassment that most of Scotland's majorities experience. I must say I find the kind of fixation on these kind of questions in the media quite ridiculous at points when we're talking about such a serious issue. Well, in terms of this, most criminal offences do not have a dwelling defence. They don't, and indeed some types of crime mostly happen within dwellings. Most crimes of murder take place in dwellings. Most rapes take place in dwellings. Domestic abuse, the Scottish Parliament legislated for in 2018, which mostly takes place within dwellings. I think this fixation on dwellings is largely because it happens to be in the Public Order Act, and having gained concessions from the Cabinet Secretary earlier, the campaigners are trying to seek further concessions. If the committee is in any way attracted to this idea, then what I would suggest would be much more coherent would be to have a requirement of publicity. Breach of the peace was historically used to prosecute often domestic abuse in Scotland, but the High Court in the case of Harris in 2009 decided that in future the common law crime of breach of the peace required an element of publicity to have an ECHR form of compliance. I think the artificial limits of the household strikes me as rather unpersuasive, but a requirement that conduct should have a public element in echo of that kind of test from the common law crime of breach of the peace would at least seem to be more coherent than this other artificial distinctions in terms of households. But broadly speaking, I tend to agree with Professor Robert Black, for example, who was quoted in the Times this week, who made the obvious point that criminal law quite often is concerned with what goes on inside people's houses, and in most cases very properly so.
Okay, thank you very much. Liam Kerr has a quick supplementary before I bring in Liam MacArthur.
Yes, thank you, Convener. Good morning. Just say on arising from that line of questioning, some commentators, including, I think, Lord Brackadale, have suggested that given that there were only, I think, 8 prosecutions for stirring up under the 1986 legislation between 2011 and 18, that the main purpose of the new offences will be symbolic or about sending a message. Does the panel agree with that assessment of the new offences? And in any event, do you take a view on whether that's the proper function of the law? Perhaps Roddy Dunlop first.
Well, it is the case that there has been historically pretty low level of prosecution for this, and in one view that's to be welcomed. If we find ourselves in a situation where the instances in which this is thought to be meeting the test, the public interest test for a prosecution, that should be welcomed. It doesn't mean that because it doesn't happen that often that we shouldn't criminalise it. I don't think that this is something that is symbolic. One sees from, in particular, social media now an increasing incidence of behaviour that is beyond the pale, that transcends the mere conveying of ideas liable to shock or offend, something that we all have to be prepared not only to put up with, but frankly to welcome in a pluralist society. But where one transcends that and gets into a world where the behaviour is abusive and or threatening, it does seem to me that that's not just a question of symbolism, that's a question that the law really ought to be stepping in to say this is not something that is to be tolerated, this is something that is a proportionate fetter on your freedom of expression and should be subject to sanction.
Okay, that's very helpful. Thank you very much. I'm going to bring in Liam MacArthur now, please. Liam.
Thank you very much, Convener. Good morning to the witnesses. Delighted to see Dr. Tickell is back online and with us. And I'll maybe reverse the order of your line of questioning, Convener. We've touched on this issue of freedom of expression. I think Dunlop, you talked about the ECHR protections that are already there that would apply in terms of any court rulings, but there have been concerns, I think, drawing comparison with the way in which the legislation is framed in England and Wales, where you have those specific freedom of expression protections linked to each characteristic. Now, the Cabinet Secretary, in his evidence the other week, made clear that he's open not just to extending the breadth of those freedom of expression protections, but also the depth as well. And just wondered whether the witnesses had any specific views on that, what they would like to see in taking the Cabinet Secretary up on that offer. So maybe start with Dr. Tickell.
Yes, I'm sorry I cut out there rather dramatically. I hope it was a coherent point. Well, in terms of the free expression sections, they are, as you said, quite limited. They're limited to 2 of the protected characteristics under the legislation, and obviously that seems rather jarring in terms of the structure. Of course, whatever this bill had said about free expression, the European Convention would apply to it. I think one of the challenges the government have faced here in drafting this proposal is that what they're trying to do is to have carve-outs for particular types of statements. So, for example, encouraging people to desist from homosexuality, in trying to capture that. It's quite difficult, I think, without having a long list of things that are not in and of themselves to amount to threatening or abusive behaviour, to draft that without ending up with a very long list of things. I mean, well, what I've suggested one effective way to address that would be to look at that reasonableness defence in general and to try and flesh that out and to have effectively, as I think the Cabinet Secretary referred to last week, a list of kind of non-exhaustive factors to be taken into account in terms of artistic expression, journalistic expression, scholarly and academic expression as examples. You may wish to add more to that because those are about, if you like, the general genre within which expressions are manifesting, and I think a court could take that into account as part of the contextual analysis of whether conduct is reasonable or not. I think there are severe limits in the approach in the bill towards free expression as you begin to accumulate just more and more statements which should not in and of themselves be regarded as threatening or abusive. So that was the only way I could devise really of really bumping up and making more robust that sense of free expression protections within the legislation, and also perhaps giving people reassurance. People will often say, journalists often think this bill is about them. I think they're generally mistaken about that. But if they are concerned about that, then at least an appearance on the face of the bill, the journalistic context of activity is a factor which the court should have regard to in terms of assessing reasonableness, would strike me as an effective way of addressing that underlying anxiety and also, you know, gesture towards the court in any future prosecution that it is a factor to be taken into account, but only one. So that would be my view about one effective way you could realise that aspiration in terms of this bill.
Thanks very much. And you answered the question I was going to ask about whether that's the face of the bill or whether you would see it in subsequent guidance, which is helpful. Mr. Dunlop, your views on that offer from the Cabinet Secretary?
Yeah, I think the difficulty with non-exhaustive lists is where do you stop before you become exhausted? Because as Dr. Tickell points out, you could have a never-ending series of factors that might be taken into account in this. And I wonder whether or not we're not already covered, as has been pointed out, by the fact that any interpretation of this Act, as indeed of any Act, must be Convention compliant. Assuming that we're not going to be recanting from the Convention, which there's absolutely no sign of, then the Act must be read in a way that makes it Convention compliant. That means if the court arrives at an interpretation of Section 3, or indeed of any section of the Act, which would itself contravene Article 10 of the Convention, then that's a bad interpretation. That's not a lawful interpretation, it's wrong in law. That being so, the particular protection that we're looking for, it would already be there. And to that extent, I just wonder whether non-exhaustive lists become more of a problem than a solution. Because when one has non-exhaustive lists, there is a tendency just to look at the lists as a sort of tick box exercise, and to use principles such as justum generis, these legal interpretive principles that we've all been grown up with, to try and actually constrain these lists, constrain the ability of these lists to enable the freedom of expression. And I wonder whether just leaving it as requiring to be Article 10 compliant is enough.
Just in response to that, is there a concern that's picked up by Dr. Tickell that those protections relate to the characteristics at present, that in a sense you appear to have a greater level of protection in some areas than you do in others, and also the view, I suppose, that you have those protections in relation to the law in England and Wales, which is obviously been updated relatively recently. We've got a bit of a sense of how that is working in practice. Do the concerns that you have in terms of those non-exhaustive lists, are they borne out by your understanding of the experience in relation to that legislation?
Yeah, I mean, again, you'll have seen that this was picked up in the faculty's response, and I would agree with Dr. Tickell's description of sections, I think 11 and 12 of the bill as jarring. You've come across them, you think, well, hang on a second, why do we have these carve-outs, particularly for those two protective characteristics and not for anything else? And that perhaps highlights the dangers of non-exhaustive lists. But I'm not aware of any particular difficulty that the changes in the law in England and Wales that have been brought in, and that's perhaps because, and I'm answering my own argument here, if you've got a non-exhaustive list and that non-exhaustive list itself has to be read in a way that is convention compliant, then it really isn't a difficulty, and perhaps it just provides more clarity. And if more clarity is welcome, if more guidance to the ordinary citizen as well as to the courts is desired, then non-exhaustive lists have a part to play. I think really my overriding point is whether they're there or they're not, the protection is there. And so really what you're saying is if these lists are to be brought in, they're more to be brought in to provide comfort or clarity. Because ultimately the protection is there in the requirement that the provision be read in light of Article 10 as necessary and proportionate before you have such a fetter on freedom of expression.
That's helpful. Michael Clancy, do you want to respond to that same question?
Thank you, Mr. McMurphy. Sections 11 and 12, of course, are exceptional in terms of the bill. And the protection which they afford for freedom of expression, of course, is not immune from criticism, can I put it like that? We noticed that the Cabinet Secretary had indicated that he was interested in the breadth and depth of these provisions, and of course that is all about who gets protected in terms of their expression. And one can see there in, let's say, section 11, that discussion of that behaviour is not to be taken as threatening or abusive, solely on the basis that it involves discussion or criticism of religion, religious beliefs and practices, or proselytising or urging persons to cease practising their religion. So one might say that those who make that kind of comment are getting an additional protection under the bill from others, except those who make comments regarding sexual orientation, which would be protected under Section 12. So where does that take us? The criticism and discussion are very wide concepts, and being able to criticise or discuss is part of our suite of freedoms of expression, which the Dean and Dr. Tickell have indicated are protected under Article 10. Do we then move to extending the breadth and depth of these protections to the other protected characteristics? That is certainly an opportunity and a possibility which I'm sure the Cabinet Secretary is pondering even as we speak.
Thanks very much, and thanks, Convener. That's it from me.
Okay, thank you very much, Liam. I'm going to bring in James Kelly next, who has some questions, I think, that are largely about Section 4 of the bill. James Kelly, please.
Thank you, Convener, and good morning, panel. Yes, I wanted to turn to the issue of plays and theatrical performances covered in Section 3 and Section 4 of the bill. And if we could maybe turn to Mr. Clancy first of all, I wondered if you could explain current law in relation to plays and theatrical performances, and whether you feel the proposals in the bill fill any gap in the current law and are therefore required.
Thank you indeed, Mr. Kelly, for that question. We have concerns about Section 4, which does replace Section 20 of the Public Order Act 1986, but it's much more stringent than Section 20, and we think presents a threat to freedom of expression in the arts. There's no justification in the policy memorandum for the drafting of this section, and it's not really clear what mischief the provisions are seeking to constrain. Extension of Section 20 of the 1986 Act, which referred to present or presenting rather or directing a public performance of a play, and Section 24, subsection 4 of the 1986 Act excludes a person shall not be treated as presenting a performance of a play by reason only of his taking part in it as a performer. And of course, that can be looked at as quite distinct from the terms of Section 4 of the bill, which it says that an offence under Section 3 is committed during the performance of a play by a person who is a performer in the play. So that then takes us to a different and significant change in the law from the preceding law. And of course, I think it's also fair to say that who presents events or directs a performance is also captured, as was the previous law, and that causes difficulties for us. There's no definition of presentation or direction in the bill, and of course you can be directing a play when you are not present during the performance. That, I think, many directors would find that to be a difficult concept to grapple with, but no doubt the drafters of the bill had a better idea of these things. But then, of course, this impacts on the Theatres Act 1968, which was actually introduced to remove certain forms of censorship in theatres, and the definition of a play in the Theatres Act also includes a ballet. So I think we've got to be looking closely at what this legislation is actually trying to deal with, and whether we need to revisit the wording to make it more up to date and more modern. I hope that answers your question, Mr. Kelly.
It does indeed, Mr. Clancy. Very comprehensive as ever. Can I maybe turn then just to Mr. Dunlop, just in terms of what Mr. Clancy explained there in relation to the 1986 Act and the way in relation to this bill it's been extended in effect to be more specific about performers. How do you feel about that? Do you have similar concerns?
Yes, we do, and I have to say that when I was looking again at both our submission and indeed the bill as originally drafted in preparation for today, it did occur to me, why are we addressing plays in particular? Plays, of course, being very widely defined. Plays would include stand-up comedy, for example. It's not a play as traditionally understood. We're not just talking about Shakespeare here. Why is that being attacked or addressed rather specifically? And I think it's for historical reasons. For historical reasons that if you go back into the dim and distant, there was a need to address public performances such as plays, because that was the public performance, the primary public performance that there was in society at that time. Nowadays, far more pressing concern would be things that are said on social media, for example, on YouTube or similar. Far more pressing concerns than what might happen in the King's Theatre, I would suggest. And I wonder whether or not it's not appropriate simply to leave Section 4 out on the basis that if you have a Section 3 offence which is committed in terms of threatening or abusive behaviour or speech uttered with a view to stirring up hatred against a particular protected characteristic in the course of a play, then assuming that you have the usual criminalisation of inciting or procuring such a matter, then would that not adequately cover the concerns that might lie behind this aspect of the bill? In that, if somebody deliberately eats something of that nature and causes it to be brought to the public in the form of a play, then it seems to me that would be caught by the general offence anyway. And if that is correct, and I suggest it is, I'm not sure why there needs to be a particular and direct provision looking at plays.
Thank you, Mr. Dunlop. Those are valid points. Can I turn finally to Mr. Tickell, and just looking at the area of potential amendments here, do you share the concerns of the other panellists in terms of this area, and do you feel that it should be amended to bring it more in line with the 1986 Act, or even, as Mr. Dunlop suggests, take out Section 4 altogether? What's your views on that?
Yeah, I think I agree entirely with the Dean of the Faculty. It's completely unnecessary, and it's another good example of what has been a red rag unnecessarily waved, the kind of culture war bull of this hate crime issue. It has made performers, actors think that something special has been designed for them. The only addition that I can identify of having this in the bill is that a negligent director who, through their negligence, has one of their performers effectively commit a stirring up offence on stage would be covered by the law. Under the Criminal Procedure Scotland Act 1995, you can be found guilty, as we call it, art and part in Scots law if you're part of a common criminal conspiracy to bring about a crime. Usually the example is with bank robbers, where the heist runner and the person that wields the sawn-off shotgun and the getaway driver are all equally guilty of the crime of robbery. Applying that logic to this, if an actor, with the connivance of their director, engages in an offence, then the director is already guilty as a matter of law. So in the sense, the idea it's a dramatic change on the status quo is, I think, mistaken, and I think I would agree we would lose nothing we shouldn't lose by simply repealing Section 4 altogether. It's there because it's in the Public Order Act. It's yet another good example of why, sort of copying and pasting bits, I should say, of the 1986 Act has resulted, I'm afraid, in yet more backlash for this legislation that it politically did not require, and actually is extremely distracting, I think, from the fundamental points and issues here. So I would argue we simply repeal it because it doesn't add anything useful to the bill, and frankly I cannot conceive of what a negligent director, how could that conceivably arise? What kind of negligence could a director engage in that results in one of their actors accidentally stirring up racial hatred? I find that a sort of comically absurd kind of proposition. So I think we could repeal it and really lose nothing that we shouldn't lose in terms of the criminal law.
Well, thank you very much. I didn't think this morning we were going to hear about bank robbers, heists and ballet, but every day's a school day. We're going to move on from part 2 in a few minutes, but Liam Kerr has a few questions just to wrap up this part of the questioning before we move on to other parts of the legislation. Liam.
Yeah, many thanks, Convener. The Convener briefly alluded to police powers earlier on, particularly around search and seizure under Section 6 of the bill. What I'm interested in, the faculty called or raised concerns about malicious complaints and seizing of devices for long periods. They go on to say that the offence could lie in the mere possession of material, irrespective of the intention that we looked at earlier. And the Law Society, I think, highlighted the lack of a time period for this. So given that, to what extent do these concerns, or do you have concerns about how we amend that section? And what would you suggest that we do in relation to Section 6? Roddy Dunlop, please, first.
Sorry, can somebody switch Roddy Dunlop's microphone on, please?
Sorry, we're back on?
Yes, thank you.
Yeah. Thank you. The first thing to say is that, as I've recognised already, some of the faculty's concerns are met already by the proposed amendment, in that by taking out the likely to stir up provision, you narrow the scope for malicious complaints for abusive provisions, such for the unwelcome consequences to which we've adverted in the submission. But there remains a potential for concern, and I suggest that the safeguards that we've listed in the provisions regarding, so it says paragraph 46 onwards of the faculty submission, it ought to be looked at quite carefully, and in particular whether or not we need to be having a search and seizure provision which is far more aligned with other areas of the law, and not quite as widespread and draconian as one finds it here. But as I say, the real concern, or a large part of the concern created by the likely to stir up provision, is elided by the amendment, and a further concern, the insulting provision, if that were to go, again, that would water down the concerns we have. There is a very much a holistic approach to all of this, in that if you take away those primary areas of concern, that bleeds into all of the other concerns that we've listed.
Very grateful. Michael Clancy, do you have any further thoughts on that?
Thank you, Mr. MacArthur. In general, our view was that Section 6 lacked a lot of specification, in that a warrant granted under these provisions would lack scope and may be considered to be unduly oppressive. And we cited in our submission case of the Bill of Suspension of Home and Fenwick William LLP and Duff and Phelps Limited v. the Procurator Fiscal at Glasgow. And in that case, the terms of the warrant were limitless in date and wide in their description of the potential recoverable material, and were too vague to have sustainable validity. No one would want warrants issued under this legislation to fall foul of that sort of case law, where they would be unduly oppressive, and therefore I think we would look to tightening the terms of the provisions there in Section 6 to make it clearer and more effective.
Very grateful. I'll move on briefly to a separate issue that I explored last week, if you were watching that session, the cross-border element of this. Now, Lord Bracadale's report includes a discussion of whether Scottish courts can deal appropriately with an alleged offence in which some aspects of the case take place in a different country. Now, Lord Bracadale didn't see a need for a specific provision in the bill, but what are your views as a panel? And can you give me some indication of how, we heard from the Cabinet Secretary last week about how he felt cross-border issues were being dealt with. I wonder if you can give me any more on that. Dr. Tickell, you're on my screen, so perhaps you would like to start.
Yes, it's an interesting question. I suppose it would apply particularly to situations where you have cross-border coordination, perhaps, in the distribution of hateful materials. That might apply. I mean, in general, my understanding of how the Scottish criminal courts have adopted this is that basically, if a part of a conspiracy takes place in Scotland, then that's generally enough to establish jurisdiction to prosecute that. In terms of this jurisdiction here, obviously, in general, we apply an idea of territorial jurisdiction. So what goes on in Scotland effectively stays in Scotland. Some of the offences that you've created in recent times have had provision around extraterritoriality. I'm thinking particularly about the Domestic Abuse Act, which provides that if we have a course of abusive conduct, some of which takes place abroad, or indeed all of which takes place abroad, then they can be prosecuted here. I should say that's generally quite an exceptional approach to the criminal law, but it is one that Parliament has adopted in the past. But my strong impression is that the criminal courts, where you do have a strong association with Scotland in terms of behaviour, have generally been quite satisfied at indicting people in this jurisdiction for that behaviour, even if some elements of it do take place outside of Scotland.
Thank you very much. I think we'll move on now, unless Roddy or Michael have a burning issue that they want to add on that last point that was just covered by Dr. Tickell. Then I think we'll move on to other parts of the bill. And I know that Shona Robertson and then John Finney have questions about part 1 of the bill, the statutory aggravation. So Shona, over to you, please.
Thank you, Convener. Good morning, panel. Can I just start by asking about Lord Brackadale's recommendation that statutory aggravation should continue be the core method of prosecuting hate crime in Scotland? Can I ask the panel whether they agree with that, and does the bill effectively provide for that? Maybe start with Roddy Dunlop.
Yes, absolutely. As the committee will have seen from our submission, we have no difficulty at all with part 1 of the Act. It seems to do exactly what Lord Brackadale suggested, and what Lord Brackadale suggested is effectively a continuation of the status quo, a situation in which statutory aggravation is seen to be the appropriate way of dealing with the vast majority of hate crime in Scotland, because the vast majority of hate crime in Scotland already accompanies other criminality, and it's appropriately dealt with as an aggravation. We have no difficulty with that whatsoever.
Okay, thank you, Michael Clancy.
Like the Dean, we agree with Lord Brackadale's assessment, and we think that the bill in part 1 covers that. So we have no difficulty with the aggravations, relatively uncontroversial. There is an issue around the use of the word evince in section 1(1)(a) small 1, which I think we might come to. I don't know, but if you wanted, I could go into that a bit further.
Yes, certainly that was a further question about the use of the language. So if you want to respond to that just now, that would be helpful.
Very good. We think that the use of the word evince is anachronistic. It's a bit old-fashioned, and I could see me starting a campaign to use evince in everyday language, but that's probably not going to go very far. It's obviously something which other people have picked up on. We ought to have our law written in a way which is easy to understand, accessible, clear, and the use of language which is not currently in common usage is probably not meeting those objectives. So therefore, something along the lines of demonstrating malice or ill will might be a suitable substitute, but that's the kind of thinking that we've been having in the Law Society about that particular provision.
Thank you for that. You might be aware the Cabinet Secretary has suggested, has certainly been open to looking at that in particular, and was suggesting similar language to that you've just suggested. Just finally, Andrew Tickell.
Yes, absolutely. I mean, practically speaking, part 1 of the bill, though it's attracted almost no public commentary, is the most important part of this bill, because we know from all of the different jurisdictions in the world that have hate crime rules that this kind of aggravator is really what we're talking about when we're talking about hate crimes. Behaviour which is already criminal, where you attach an aggravator based on effectively what the accused person does in the perpetration or immediately before or after the offence. Very often, and I'm sorry to come back to this, but this bill has often been junked in the media as if it's comprehensively awful, ghastly and misconceived. Well, if you say that, you're junking aggravators as well, and they are not only the law as it stands, but they're also the tremendously important way of marking out this kind of behaviour as being, as the name suggests, aggravated, as being additionally wrongful. If you pick your victim based on your perceptions of their characteristics, then that is one of the critical ways that hate crime is realised, and affected in our country, and I think it's critical that this bill recognises that. One thing I am struck, though, is I'm surprised there hasn't been more conversation in the parliamentary debate about whether the factors and characteristics listed here are comprehensive enough. I mean, if you look at some other jurisdictions and how they approach things that can potentially aggravate offences, look at Professors Leverick and Chalmers' report to the Bracadale Review as a very accessible route of doing this, you will find additional characteristics there. And one that I personally would have a lot of sympathy with adding to this list is the characteristic of homelessness. We know that people who are perceived to be homeless are much more often likely to be victims not just of street harassment, not simply of abuse in the street, but also assault by members of the public, simply by dint of the fact that they do not have a home to go to. And I think that that's the kind of thing which it's unfortunate, perhaps, that we've got locked into the existing characteristics, partly because of this terrible fixation on these stirring up offences. And I think there is perhaps an argument, at least worth contemplating, about whether there are other things which might and perhaps should feature in that list of aggravating factors based on the social experience of Scotland and the people we know who tend predominantly to be victims of crime. That, after all, is what this bill is mainly about.
Thank you. That's a very interesting thought, which I'm sure we'll reflect further on. That's all from me, Convener, and I know there's other questions in this area for colleagues.
Thank you very much, Shona. Yeah, John Finney, I think, also wants to come in this area. And then after John, I think it'll be Annabel Ewing, unless she thinks that her question's already been covered. But John Finney first.
Thank you, Convener. Good morning, panel. I have questions for Mr Clancy and Mr Dunlop, individual questions about the evidence they've submitted. So, Mr Clancy, as you did a minute ago, you welcomed the continuance of statutory aggravations. In your evidence, you said the statutory aggravation model should continue to be the means used for prosecuting hate crime to maintain similar and appropriate thresholds for criminal offending as exist at present. Can I ask, are you satisfied that the thresholds for criminal offending as outlined in the bill are appropriate, please?
Thank you, Mr Finney. Yes, we are, subject to the issue about insulting, which we've discussed earlier in this session. And of course, when our submission was written, the provisions which have now been signalled as being subject to amendment by the government were that signal had not yet made its way through to anyone. So I think we're on solid ground here now by saying that we're content in that respect. Yeah.
Okay, thank you very much indeed. Mr Dunlop, in relation to the faculty's evidence, if I may please, you said that based on the consistency which the unified approach would achieve with other existing hostility aggravations, which he considered, this is Lord Bracadale, to be more easily understood by practitioners and the public. And again, my question to you is, do you believe the bill delivers that unified approach with other existing hostility aggravations? And will the public understand that? And indeed, is that public understanding important, please?
Yes, I think it does consistently do what Lord Bracadale suggested should be done, and really what it's doing is, and here we're talking about part one of the Act, it is extending the existing list of aggravations to a wider range of protected characteristics. That seems to me to be consistent with the aim of the bill, as long as it is done with along with the amendment we've already discussed on the question of taking out the likely to stir up aspect, making it a crime of intention only. And I would say, echoing Mr Clancy, also addressing the insulting concern, then that seems to me to raise the matter to a level at which these things should be criminalised under Part 2 and under Part 1 on the question of the aggravation. I don't have any difficulty with that whatsoever, because really what it's saying is, if you're committing a criminal act already, and if you are doing that because of hostility towards the protected characteristics, and the lists of protected characteristics are already well understood in terms of employment law, for example, then that seems to me to be entirely appropriate and to be exactly what Lord Bracadale was suggesting.
Okay, thank you very much indeed, Mr Dunlop. A question for all of the panel, if I may, please, and come to you, Dr Tickell, first perhaps. Lord Brackadale recommended repealing the offence of racially aggravated harassment. The Scottish Government didn't accept that recommendation. I wonder if, is it your view that perhaps the other characteristics are being sold short on that aspect, and is it creating a hierarchy? If you could comment on that, please.
Yes, I mean, I think, well, a couple of thoughts on that, I suppose. Firstly, if we're going to keep this offence of racially aggravated harassment, then there is no argument whatever for it not to be in this bill. If one of the key reasons to have this bill is to consolidate the law, then frankly I find it crackers that it isn't present in this consolidating measure. As you say, the Scottish Government didn't accept that recommendation. I think that does raise questions about what additional contribution or additional protection this particular 1995 offence has contemporarily in Scotland. We know it's been used a lot by Scottish prosecutors. However, threatening or abusive behaviour aggravated on grounds of race would seem to cover, to me, much of the same materials. But if it is to be retained, then it has to be retained in this bill, surely. If it's a consolidation measure trying to end fragmentation, then I find it quite incoherent that it isn't present in this bill. I think it's undeniable that that idea of treating all of the protected characteristics equally has no longer a kind of structuring force in terms of this bill. The Scottish Government's decision to try and protect the issue of race, if you like, has resulted in more complexity than would otherwise be the case. It's probably also worth stressing here how the law defines the idea of race, because it doesn't define it in the way that perhaps the ordinary person might assume it's defined. It applies much more generally to national origins, citizenship, as well as questions of race and ethnicity. And that's perhaps a wider framework for that activity taking place and potential forms of abuse than many people might immediately realise. So personally, I would be in favour, in echo of Lord Brackadale, of simply repealing it. I think perhaps one of the reasons why it hasn't been repealed is because I think organisations like Engender probably wish to model a form of misogynistic harassment on that Section 50A offence, and therefore that's perhaps one of the reasons, in addition to those given by the Cabinet Secretary, why that hasn't been and isn't proposed to be repealed by this legislation.
Thank you. Mr Clancy, Mr Dunlop, do you have a comment on that, please?
I agree that consolidation could mean consolidation, and therefore, where there are exceptions to that proposal, I mean, consolidation is a good idea generally, both for the public at large who are affected by these laws, and for the practitioners who operate them, whether they be defence solicitors or prosecuting procurators fiscal. So I think the continuance of Section 50A of the Criminal Law Consolidation Scotland Act of 1995 looks then out of kilter with the concept of consolidation. And we've been trying to consolidate law for a long time. The Scottish Law Commission, which was founded in 1965 in the Law Commissions Act, has as one of its objectives consolidation of the law. So if we're looking at that as a sort of national objective for the law, we should be doing exactly what that means, especially when it's reinforced by a judge-led report.
Mr Dunlop, do you have anything to add at all, please?
Yes, I mean, I wonder to what extent it's the optics of this that are proving crucial. We've already spoken about the retention of the provisions on insulting. I think that's largely being driven by the fact that's been on the statute book since 1986, and there's a concern about the optics of taking it out. Somehow you're diluting the protection that's been there since 1986. Provisions regarding the broadcasting of or the performance of plays have been on the statute books for decades, and there's a concern that if that's taken out, again, you're diluting the protection. And I wonder if this isn't a very good example of that. Well, the last thing that the optics could possibly allow is to be getting rid of a legislative provision that has been used by prosecutors on a regular basis that has provided protection. I would say two things. The first is I wonder to what extent there is an ongoing need for the Section 80A offence, given what's being enacted by the bill. Where are we seeing that there would be an additional element to this that wouldn't otherwise be caught by what is struck at by the bill? But to the extent that there is an ongoing need for that, it seems to me that that really ought to be, in echoing the other panellists, really ought to be included in the Act. The whole aim of a consolidating statute is to have the whole law of a particular genus in one place, so that one can go to that Act and find out what's allowed and what's not allowed. And the suggestion that we have this hangover offence, that you have to go to a completely different statute, and indeed an amendment to a completely different statute, doesn't seem to me to be coherent. If you're going to retain it, keep it.
Okay, thank you very much indeed, panel. Thank you, convener.
Thank you very much. And I think Annabel Ewing has a question also relating to this area. And then after Annabel, it'll be Ronan Mackay, please. But Annabel first.
Thank you, convener, and good morning to our panel. I would want to pick up on the threshold test issue of the evincing of malice and ill will briefly. Firstly with Michael Clancy, but before going to Michael, I think it would be appropriate to refer members to my entry in the register of interest, wherein they will note that I am a member of the Law Society of Scotland, that I do hold a practising certificate, albeit that I'm not currently practising. If I could ask Michael Clancy, he's not happy with, or Law Society's not happy with the evince bit of this, but seems to be content with the malice and ill will bit of it. He'll recall that Lord Bracadale actually recommended that we use the phrase demonstrating hostility. And I think the Crown Office and Procurator Fiscal Service has said that in their view, that use of the use of that phraseology would not change the test. So I just wonder what would be the position of the Law Society on that particular point.
You ask a very interesting question, as always. I think we have settled on malice or ill will because it is a well understood phrase. It isn't particularly out of popular usage, certainly not as much as evince is. And I think that a body of case law is present for us to reflect on malice and ill will. But that having been said, if hostility is shown to have exactly the same characteristics, and I'm not sure that it does, as malice and ill will, then we would examine that closely and give a view on it.
I thank Michael Clancy for the answer. Could I just briefly ask our other two witnesses? First of all, could I go to Dr. Tickell and then to Roddy Dunlop, please? Thank you.
Yes, I think it's a very good question, actually. I mean, evincing malice and ill will does sound rather kind of Dickensian, doesn't it? It sounds slightly old-fashioned. Personally, I don't really see how shifting from the language of evincing malice and ill will towards demonstrating hostility is likely to dramatically change the scope of aggravators here. Not least, remember, because aggravators have to be attached to underlying criminal behaviour, and if the underlying behaviour is not criminal, it cannot be aggravated. So I don't see that shift towards a demonstrating hostility model, if you like, as Lord Bracadale recommended, is likely really to add or subtract anything dramatically from the scope of these aggravators. And I think from the perspective of the ordinary person, that demonstrating hostility is much clearer than the idea of evincing malice or ill will.
Thank you for that. That's one for each side. Mr. Dunlop, you've got the casting vote for this morning's purposes.
Well, I live in a world inhabited by those using Dickensian language, so I don't have any particular difficulty with the notion of evincing. And in fact, the notion of malice is arguably a more elusive one. If one passes into the world of defamation, in which malice is a recurring concept, malice can mean more than one thing. Malice means different things under the law of fair comment than it does under the law of qualified privilege. Malice can mean intent to harm. Malice can mean having an ulterior motive. So to that end, if the aim is to make things simpler, for the man in the street, then I can see considerable merit in getting rid of the more Dickensian language and saying demonstrating hostility, because that is a pretty easily understood concept that doesn't have the wriggle room that the notion of malice might have. Because, as I say, malice means a number of different things in a number of different contexts in the law, and therefore I see some attraction in saying let's say exactly what this means, and that is demonstrating hostility.
Thank you for that. I think the jury's out on that one, and obviously the committee will have to reflect further. Thank you, Convener.
Thank you very much, Annabella. And while I'm delighted that we've had references this morning to both Shakespeare and to Dickens, can we please stop using Dickensian as a pejorative term? And with that thought, Rona Mackay, over to you.
Thank you, Convener. Good morning, panel. I'd like to just return, I know we've covered the different approach to race extensively, but it's just a brief couple of supplementaries I'd like to ask Roddy Dunlop and Michael Clancy. I have a separate question for Andrew Tickell. So we know that stirring up racial hatred offences have existed since 1986 in all parts of the UK, and so that's not new. Last week in evidence, the Cabinet Secretary told us that 2/3 of all hate crimes related to race, and that last year there was 3,038 racial stirring up offences. Do those figures not make the case for not removing the word insulting, for it to have a certain for it to be an exception? And by removing insulting, as Roddy Dunlop was talking earlier about, would it not dilute the importance of the severity of the level of hate crimes relating to race?
Sorry, we need to unmute Roddy Dunlop, please.
I pose the question of how many of those motions were peddled, or those convictions were peddled on the notion of the word insulting. And I'll warrant the answer is none, or almost none, because we come back to the point I made right at the outset. It is very difficult to conceive of a situation in which the language that has been used is not threatening, is not abusive, but is deemed to be insulting in a way that says that should be criminalised. And I've been trying to figure examples that might help here. I mean, for example, picking up on Dr. Tickell's point about race includes national origin. So all Scots are stingy. Well, is that abusive? Probably not. Is it threatening? It's definitely not. Is it insulting? Probably. Do we want to criminalise that sort of matter? Is that not something that is really too venial to merit the attention of the law? I would suggest that it is. So really, I come back to the point that was made by the English legislature when they were looking at the background of the notion of insulting, and the view was taken that you can remove that word without having any material impact on the legislation, because there are no prosecutions that turn on that word, no realistic risk of dilution for that very reason. So I would not be concerned by that. Rather, my concern lies the other way around. If you have that subjective notion of insulting, it is ripe for abuse, and not so much ripe for abuse in anticipating that there's going to be a conviction. Because if you're reading it as Article 10 compliant under reference to the Hungarian case I mentioned earlier, you're probably never going to get a conviction. It's the anterior stage where it's subject to abuse, it's subject to misuse, malicious complaints, and then the potentially draconian effects of a search without warrant, etc., on the basis of retention of devices, etc. Very easy way to get back at the neighbour you don't like. You make the complaint, all the computers get seized, etc., etc. All the potential cascading effects that one might have from that. So I would not see it as a dilution. Rather, I would see it as a necessary fortification of the protection for freedom of speech.
Thank you. Mr. Clancy?
as the Dean has said, there are good arguments for removing insulting. Lord Brackadale recommended that the word insulting be removed. I suppose one could approach this on a couple of ways. You could either remove insulting from the provisions of section B1, or you could add insulting to the provisions of B2. But neither of those sounds quite right in terms of adding insulting to the provisions of 3.2, because of the idea that there should be equality before the law. Retaining insulting creates a suggestion that somehow or another there is a hierarchy of offences, and somehow or another some people who may be accused of committing an offence are put to an additional hurdle. The bar there of insulting is quite low, it's subjective. On the point which you make about the numbers of offences, then of course one can see that clearly the use of racial epithets or insulting or threatening or abusive behaviour is a serious problem in Scotland, and that's probably an issue which you would like to return to when you speak to the police officers later on. But obviously, if the net of behaviour is larger, as it is by including insulting, then there is a potential that that of itself is a source of the larger amount of prosecutions under the previous legislation. I kind of think that if we were to remove insulting, the cohort who persist in making threatening or abusive comments towards people in the groups mentioned in section 3(2)(b) or 1b rather, for the purposes of stirring up hate, they're not going to stop trying to stir up hate against these groups just because insulting is not part of their weaponry. They will still continue to be threatening and abusive, and will still need to find themselves subject to the law.
Thank you. That's very interesting. Can I turn to Andrew Tickell, please? Andrew, in your submission, you say that the bill risks becoming mired in hyperbole and confusion. In evidence last week, Lord Brackadale said that when he published his review, which is obviously broadly represented in this bill, there was, little or no pushback. So I wonder if you could maybe say why you think that this hyperbole and confusion is now happening now that we're taking evidence.
Yes. Yes, well, I suppose there's lots of reasons for that which expand far beyond Scotland, in the sense the bill is an intervention at a number of intersections of what can be thought of as kind of culture war type issues. I mean, whether we're talking about criticisms of religions by atheistical people, whether we're talking about criticism of Islam, whether we're talking about churches criticising homosexual lifestyles, whether we're talking about homosexuals criticising churches for criticising their lifestyles, whether we're talking about transgender reform and issues around the Gender Recognition Act, this bill has something for everyone, and hence the wild coalition that was formed very improbably behind its proposals. I have to say I feel rather naive by saying it risked being mired in hyperbole and confusion. I think that miring has more or less entirely happened now, and I really do regret that. I think we're losing the point here. Some time ago I wrote an article in a newspaper about one of the worst experiences I have encountered as a teacher with hate crime, where I had a number of young students at Glasgow Caledonian University some years ago who came to me and said, I cannot come to class because I've seen reported in the newspapers and on the air that tomorrow is Punish a Muslim Day. And I can't think of a more heartbreaking moment in my history as an educator. I mean, what does one say beyond burning with fury at the experience of young, principally women, who are part of my class in their own city, who feel that way? And I find the way this bill has been discussed from a position of often extreme casual privilege be quite repulsive, to be honest, at times. There are legitimate questions about free expression, and I posed them, as you'll have seen from my submission. It's absolutely right, as I said at the outset, that this bill is anxiously scrutinised for its undoubted potential to chill free expression. I believe very passionately that is important. But I find the bloodlessness of the discussion of hate crime as if it's some kind of woke, nonsense and virtue signalling. I find that a deeply inhumane and unrecognisable thing. And I suppose I would ask critics of this bill who talk about the bill in that way, what would they say to my student who came to me and said it's Punish a Muslim Day, so I'm afraid to set foot in my university in Glasgow? I felt profoundly ashamed of the fact that that was something that anyone could experience in our society.
Thank you. Thank you for that. Thank you, Convener.
Thank you very much, Rona, and thank you for that, Andrew, too. We're going to move on to explore some of the other hate crime characteristics. And I think Fulton McGregor is going to lead the questioning on this, Fulton, and then after Fulton it'll be Annabelle. Fulton.
Thanks, Convener. Good morning, panel. I'm going to leave the issue around sex and the list of hate crime characteristics to my colleague Annabelle Ewing, because I know that she was following that up last week. So I want to start by asking about some of the suggestions that we've had that hate crime characteristics may include covering gypsy travellers, for example, asylum seekers and refugees. And I wonder if I can ask the panel, do you think there's any merit in this and these groups being added, or do you think that they're already covered by the characteristic of race? And I suppose, just for the sake of time, because I know it's been a particularly long session, I'll ask my second substantial question at the same time, and that's about the bill not including any specific provisions for dealing with sectarianism. Do you think that it should, or again, do you think that the hate crime characteristics of race and religion, as defined, are suitable enough to cover sectarianism? And I don't have a particular order, Convener. Would you like me to suggest one, or happy for the panel to? Okay, well, Michael Clancy first then.
Thank you very much indeed, Mr. McGregor. The Societies Committee did not specifically consider the issues of gypsy travellers, asylum seekers or refugees in looking at the bill. It may be the case that some of the people who fall into these groups would be covered by aspects of the bill, for example, in terms of the Section 3(1) provision and the crime which is created under Section 3(2). So therefore, because they might belong to a race or ethnic group or have specific national origins, and that would apply presumably to asylum seekers and refugees too, but there may be issues which would cause some difficulty in putting those characteristics into the provisions for race, but that would have to be dealt with on a case-by-case basis, and would be something which the prosecutors, the Lord Advocate, would have to consider when seeking to make their decision about a prosecution for a breach of provisions of Section 3. I hope that gets to the point that you're looking for. On the issue of sectarianism, we had noted that sectarianism was not provided for in the bill. Again, there may be a shadow of it in terms of Section 3(3)(c), which talks in terms of religion, or in the case of a social or cultural group, perceived religious affiliation. that is, if you take sectarianism to relate only to religion, but sectarianism can be related to other factors as well, which some of which again come up.
I don't think it's just me. It looks like we have lost Michael Clancy there. Oh, he's back. Michael, whatever it was he said in the last 30 seconds, we lost. So can you, if you can just wrap up, then that would be very helpful. Thank you. No, he's lost again. So Fulton, do you want to direct that question to Roddy Dunlop next?
Yeah, thanks. I think I got the gist of where Michael Clancy was going. But yes, if we move on to Roddy Dunlop. Great.
On the first question, it does seem to me that the wording that's used at the moment will adequately protect the groups that you've mentioned. I mean, for example, you mentioned gypsies. This jurisprudence that there is in this area in regard to protection under employment law, for example, where protected characteristics are already well understood. And I think I'm right in saying that Irish travellers and Romani gypsies have both been recognised as ethnic groups for the purposes of employment protection. And by the same token, it seems to me that would make those particular groups fall under the definition in the Act for race, colour, nationality, ethnic or national origin. Ethnic or national origin is sufficiently wide to cover the groups that you mentioned, likewise asylum seekers. So I don't think there's any difficulty there. Scotland's particular difficulties with sectarianism are always going to throw up difficulties, and we're well aware of the ill-fated attempts to deal with them in terms of the football legislation. Again, it seems to me that the provisions in terms of the Act are sufficiently flexible to deal with problematic sectarianism, because if you're dealing with behaviour that is, for example, threatening, and it's threatening on the basis of religion as defined in the Act, as Mr. Clancy points out, then there is a flexibility there. There is also some dubiety, and again, faculty has alighted on this in the submission. There is a potential vagueness in terms of the definition of religion, or in the case of a social or a cultural group, perceived religious affiliation, and exactly what's meant by that. But as the question is, will it sufficiently catch sectarianism that should be criminalised? Then yes, it will. Is it potentially too wide to catch activity that might be thought problematic? Again, I come back to my central point. As long as we take away the potential for accidental criminalisation by removing the likely to stir up provision, then faculty's concerns in that regard have been addressed.
Okay, thanks for that. And Dr. Takelo, have you got any thoughts in this area?
Yeah, so I suppose it's worth stressing that the perception, if you like, is the perception of the accused person of the characteristics of their victim. So in that sense, if they perceive them to be, of an ethnic minority based on whatever basis, then that's likely, as Roddy Dunlop just said, to be caught clearly by this. You've mentioned the S word, sectarianism. As Annabel Ewing will know, when the Football Act was being repealed, at the instance of the Justice Committee, in fact, a group was formed to look at whether we should have a legal definition of sectarianism. That has been largely memory hold. I think it went down like a cup of cold sick, to use a technical legal term. What we recommended in context that you could have a definition of sectarianism. I think it would be fair to say that caused considerable controversy and didn't persuade everyone of it. I think one of the distinctive features of sectarianism in Scotland is that it's what the American scholar Kimberly Crenshaw would describe as an intersectional issue. And it's perhaps a missed point here that Lord Bracadale didn't really use that language of intersectionality, where you have people being targeted because they have a combination of factors, not simply one. You know, it's not simply an accident of gender or an accident of sexuality that sees lesbians, for example, being invited to kiss each other by strangers on buses. It's an intersection of both their sex and their sexualities. And sectarianism is not so different in the sense that it's a toxic combination often of ethnic origin questions and Christian denominational questions of a range of forms. This bill won't address that, and the language of sectarianism will remain elusive in legal terms, even if practically, for example, someone who does engage in this kind of sectarian behaviour would be caught by the bill. I mean, one good example was the assault against Canon White, famously in Glasgow, who was spat upon and subject to abuse based on not only his religion, but also his perceived Irish national origins or citizenship. At the very least, the way the aggravator is constructed in this bill means you could much more tidily combine those two elements. But that language of sectarianism will not be used. For some people, that will probably be a good thing. Some people would argue to use the language of sectarianism is to have a sort of false equivalence, effectively, and to throw a cloak over predominant anti-Catholic and anti-Irish feeling under a language of sectarianism, and would insist that the language of race is much more appropriate around that. So that's where we are at the moment in terms of it. It's clearly an omission in terms of the legislative language of this bill, though having worked with colleagues to try and define sectarianism, it is no easy thing to do, and as we encountered, it caused very considerable controversy, which I suspect that the bill does not need any more of.
Okay, convener. I just want to thank the panel for all the quite detailed answers there. Happy for you to move on to Annabel Ewan, but there was a final question I had, which I think would be better placed after Annabel's question. But maybe I could just ask the panel when they're responding or summing up, if they have any concerns about the way in which various hate crime characteristics are defined in the bill, further to what they've already spoke about in answers there. Thanks.
Perhaps, as Fulton suggests, I can bring Annabel in at that point, and if witnesses want to respond to what Fulton just said, they could respond to Annabel and Fulton in a one, which is another technical legal term. Annabel, thank you.
Thanks, Convener. Turning to an obvious exclusion at the moment from the bill, that is the characteristic of sex. And the panel will be aware that what seems to be happening is that there's a sort of parallel working group be set up, not set up yet, to look at creating a standalone offence of misogynistic harassment. And I just wonder, it would be interesting to hear from the panel their views on this approach and what, if any, risks they think it may involve. And also in terms of process, there is a kind of get out of jail card in the sense that it is proposed to have a provision in the bill to allow secondary legislation to be brought forward to introduce the characteristic of sex within the scope of the legislation, and what the panel feel about that process and its appropriateness or otherwise when we're dealing with very serious criminal offence issues. So perhaps I could turn first to Roddy Dunlop, then Michael Clancy, then Dr. Tickell. Thank you.
Yes, this is a situation or a question that the faculty addresses towards the end of its submission, and we note the recommendations of Lord Brackadale. This is obviously a controversial area, but the question that arises most clamantly, I suggest, is that when you've got protected characteristics well understood as including the questions of sex in many other contexts, why is that not being addressed at the same time in this matter? And therefore I well understand why the view is expressed by many that this should be addressed at the same time in this Act. Equally, it gives rise to a variety of considerations that are looked at by Lord Brackadale, and that's doubtless why it's been stripped out and looked at separately. It seems to me that it's a quintessentially political matter, and I understand why it is being taken separately. What it very much needs is consideration and mature consideration. and if it's not thought possible to put it through at the same time as this Act, then okay, as long as it is achieving the consideration that it needs, because it is it's fairly obvious. And again, you just need to have the merest glance at Twitter or any other form of social media to see that there are difficulties with misogyny in the same way as there are with the other species of hate crime that the bill is directly addressing.
Thank you. Mr. Clancy.
Thank you very much, Mr. So the Society similarly is looking forward to hearing what the working group on the sex characteristic is going to produce. It's a matter of policy as to whether or not the government does go down that road. What we would say about Section 15 is generally that the way in which this is being approached in the bill perhaps is potentially problematic. There could be the creation of crimes under these regulations. It's not necessarily a bar to this being dealt with by regulations, but we think that where a new crime is created, particularly, as the Dean has indicated, in what is likely to be a very controversial area, then it should receive the fullest scrutiny of the Parliament. Of course, in the first instance, that would suggest primary legislation to implement any change. But if the government is insistent on using regulations, then we think that those regulations should be subject to super affirmative resolution procedure, so that there is opportunity for the relevant committees of the Parliament to take evidence on the terms of the provisions of the regulations and to be able to ask the government to think about amendments to those regulations. So that's where we stand on the issue at the moment.
Thank you. Dr. Tickell.
Yes, I think I agree with much of what has been said thus far. I mean, obviously it's not the most satisfactory way to achieve a consolidation, to have an ongoing uncertainty about a core element of what would look like the global picture of hate crime after this bill has passed, but that's, I suppose, where we are. In terms of the underlying issue, should sex be a protected characteristic for aggravator purposes and, stirring up offences, and should there be a separate issue of misogynistic harassment? I do think that raises some really fascinating and important questions around, gender neutrality in our law has been something that we have been moving towards in general, but echoing what I was saying about the sectarianism example, how many men are subject to misandric harassment on the streets of Scotland? I'm not sure I've met any. I certainly haven't been myself. So if the social reality is one thing, then I can perhaps see the argument that the law should reflect effectively the misogynistic framework within which that kind of harassment occurs to more or less every woman I've ever met in my puff. So I think it's unsatisfactory that we are where we are with this. I would agree with Michael Clancy that scrutiny of these proposals will be important, and it will, I think, raise fascinating questions of principle about how far do we want our law to be gender neutral, and how far effectively, by making the law gender neutral, are we simply disguising the gender inequality in our society? Because that ultimately is, I think, what this whole debate is driving at. And I know in terms of other people can speak for themselves around this, but there are wider questions about lots of other crimes which would be interpreted through a feminist framework as really being motivated by and rooted in misogyny and hatred of women on some level. So I think that's a difficult thing to realise in the law. Can we think of examples of serious sexual offences which are not, to some extent, failing to recognise the full humanity of a female victim in these contexts? So I think that's the kind of debate which is sensitive and complicated, and it would have been far preferable if we could do this all in a oneer instead of doing it in this very fragmented way.
I thank all of the witnesses for their comprehensive answers, and obviously we've been given further issues to reflect upon when we come to consider this issue. Thank you, Convener.
Thank you very much, Annabelle. And I think the final questions will go to Liam Kerr.
Very grateful, Convener. So first question, I direct first to Roddy Dunlop, followed by Michael Clancy. Last week, I put to the Cabinet Secretary the concerns of the SCTS around the financial memorandum and the costs associated with this bill. Can you, Roddy, first tell us what resource implications does this bill have for the legal profession and the courts, and are these, in your view, adequately reflected in the financial memorandum?
I can't instantly think of a particular. There's no impact on the legal profession itself. I mean, if this leads to more prosecutions, that's going to lead to more business for the legal profession. Is it going to lead to resourcing problems for the police? I think is the real concern here. That again, I come back to the question of whether or not the right balance is struck. If the right balance is struck, such that one is only targeting people who are setting out with intent to stir up public hatred, or who are already committing crimes anyway, so that's part 2 of the Act followed by part 1 of the Act, getting them the wrong way around, then I don't really see that is going to create a massive additional problem. The proof of the pudding, as always, will be in the eating. And it is important to recognise that we are expanding the aggravations beyond those presently in existence to deal with all of the protected characteristics. But is that going to involve a huge resource implication? I don't think it will. So that's not something that seems to me to be a consideration that ought to concern the committee.
Very grateful. Michael Clancy, do you have any other answer there?
I think that it's quite likely that lawyers will require additional training when a new consolidation measure like this reaches the statute book. There's always a potential for a flurry of activity in the continuing professional development area, and I think that certainly will be something that people will want to learn about, is this aspect of how the law will work in the future and the changes from the law as it has worked hitherto. So there'll be training for lawyers, both in the prosecution and defence areas. There'll be training for the judges, which the Judicial Institute, I'm sure, will take on willingly, and I suspect for others in the justice system, especially the police and potentially social work departments as well, because if people have been subjected to threatening or abusive behaviour, they may need additional supports across the piece. But that doesn't tie into the financial memorandum, and if we have any further thoughts on the financial memorandum or the impact assessment, we'll come back to the committee on those.
Very grateful. Convener, with your indulgence, I'll ask one final question of Dr. Tickell. Dr. Tickell, I was very interested in all the submissions, but yours particularly at the end, where you refer to Thomas Aikenhead, and that striking blasphemy will be a small restitution. Now, looking into this, Aikenhead, I think, and I'm paraphrasing, of course, but Aikenhead was indicted for having engaged in conversation with friends at the University of Edinburgh, in which he suggested in much stronger terms that Christian religion was, quote, nonsense. Slightly philosophical question I'll pose to you, but isn't there a possibility that in repealing blasphemy, but incorporating some elements of Part 2, it could be argued at least that challenging the prevailing orthodoxy might bring, under this bill, might bring in blasphemy by the back door?
No, no, I don't think so, Liam. To be honest, I mean, yes, Thomas Aikenhead, a 20-year-old university medical student who denied the Trinity, who mocked the history of the impostor Christ and who pretended he was a magician to poor fisher folk in and around Israel, was his criticisms. He was ratted out by his friends, and thanks to the Lord Advocate of the day and the General Assembly of the Church of Scotland, he found himself throttled by the hangman, aged just 20 years of age, and all cries for mercy turned away. You know, the last man in this country to die for the crime of blasphemy. So his ghost at least will be laid to rest if this element of the bill passes, and I would welcome that. I think going back to the initial point we started with these new thresholds since the Cabinet Secretary has introduced these changes, we need to prove threatening or abusive behaviour that would stir up hatred against the protected characteristic and is not reasonable in context, and of course taking into account that idea that criticism of religion is an important part, not just of Article 10 but also of Article 9, freedom of religion or lack of belief under the European Convention. So although I can see the sort of rhetorical charms of envisaging this as a new form of criminalising the Thomas Aikenheads of our own time, I wouldn't accept that looking at the detail of the bill. But I would welcome very, very strongly repealing the offence of blasphemy. It's existed for far too long on the Scottish Statute Book, as Mr Aikenhead reasoned to his terrible cost.
Very grateful, thank you.
Consensus on which to bring this to an end. It's been a very long session. I'm very grateful to all of our witnesses for their time and detailed consideration this morning. You've all helped the committee very much with our deliberations on this really important bill. I'm very grateful. We will suspend for 5 minutes before reconvening at 11:54 for panel 2. Thank you very much. Thank you very much. Welcome back, everybody. And I welcome our second panel today. And let me start with an apology to them all for keeping everybody waiting for so long while we explored a variety of issues with our first panel this morning. But now, in front of the committee, we have with us Assistant Chief Constable Gary Ritchie from Police Scotland, Callum Steele, the General Secretary of the Scottish Police Federation, and Anthony McGinn, Procurator Fiscal from the Crown Office. You're all very welcome. And as with the first panel, I'm not going to invite you to make opening statements because that will just use up even more time, which we don't have. We're going to launch straight into questioning, if you'll forgive me. And I want to start with the questioning for this panel exactly where I started with the first panel earlier this morning, and that is, given the nature and tenor of your written submissions, it's obvious that you will welcome the Cabinet Secretary's proposed amendments to the stirring up offences in Part 2 of this bill. But the question is whether they, in your view, go far enough to ensure that the bill does everything that it needs to do to protect fundamental human rights such as free speech, privacy and fair trial. Perhaps I can direct that question to Assistant Chief Constable Gary Ritchie first.
Yes, thank you very much, Chair. I appreciate the opportunity to speak today. I think I'll preface my comments just by saying that from my perspective and from the police perspective, there's two main considerations which I think should apply in terms of our examination of the legislation as it's proposed. The first being the ability of the enforceability, if you like, of the legislation. In a practical sense for policing, and how realistic it is, and how it helps us respond to that public demand and expectation, first of all. And then the second element, and this is something that we've seen quite a lot of recently through the establishment of the coronavirus legislation, and it's very much that consideration of how an intervention of policing is likely to affect public trust and confidence in the police, because that obviously impacts on the fundamental principle of policing by consent and legitimacy. So all my answers today in terms of the response and the official position of the police service is going to be based around those two principles. In terms of your specific question, yes, we welcome the proposed amendments and the provision of the intent principle. I think for two reasons. First of all, it creates an equivalence across all the protected characteristics, and I think, as been mentioned before, it then removes the potential for that hierarchy of discrimination to be perceived by members of the public. And it provides that consistency, I think, for policing as well, so that it's just quite simply easier to understand. It makes it easier to get the message across to our officers. It makes it easier for our officers to apply the principles and apply a threshold in terms of when an offence has been committed. And I think the second principle, again, touching on what I was saying before, you know, having intent really is the basis of, you know, all interventions as far as the police is concerned, and that provides a very strong threshold, and it's just a lot clearer in actual fact and practice.
Thank you very much. Could I ask the same question to Callum Steele, please?
Yes, thank you, Convener. I think, like the three previous witnesses, the Scottish Police Federation absolutely welcomes the amendments that have been identified by the Cabinet Secretary. I think they substantially move towards alleviating a lot of the concerns that would arise for police officers and indeed the reputation of policing and managing the public expectations, I suppose, when it comes to the enforcement of this legislation, and certainly removes a lot of the areas for conflict. The likely provisions in their own right were, I think, fairly recognised by a large number of contributors as being by far the most controversial. And as I think was properly picked up by Mr. Dunlop in your earlier session, that also addresses, or certainly goes a large way towards responding to the risks that would have accompanied that in terms of search and the pernicious effect that could have on the relationship between the public and the police service. There do, of course, remain some other elements which won't be lost on you. We identified in our submission. Not least amongst them is the fact that the proposal to grant powers of search to members of police staff still remains. The ability for police officers to exercise, powers over the public is something that's generally well accepted. Extending that to police staff who do not have the same limitations placed on their own activities in their private life, and also not subject to the same disciplinary regime, is something that I believe parliamentarians should consider very, very carefully. Whilst I'm sure we'll probably get into this in the rest of the section, the rest of this evidence session, some of the comments that were made regarding the moving away from subjectivity towards objectivity in terms of tests that should be applied by police officers will be very helpful. I do think that there will be inevitable demands placed on the service. Whenever anything new is introduced into the statute book, and there's an expectation that there's going to be enforcement from a policing perspective, the requirement to record and to measure and to report on that tends to be often understated in accompanying financial memoranda. I'm sure that ACC Ritchie may well touch on that himself later on. But generally, the removal of the likely provisions substantially address a lot of the concerns of the SPF.
Thank you very much. And the same question to Anthony McGinn, please.
Good afternoon, Convener, and thank you. The restriction of the stirring up offences in relation to the majority of the protected characteristics on the basis of intent only is welcome, providing welcome clarification in relation to the behaviour that will be criminal. I would highlight a consequence of that restriction is that it expands the difference between the approach taken to the majority of the protected characteristics and that of race in relation to offences based upon race. As touched upon in the earlier session, those offences include behaviour that is insulting, and it also includes behaviour that is likely it will stir up hatred against a group based upon the racial characteristics.
Thank you. I've got three follow-up questions, and I'm going to ask them all together in the interests of time, and invite you to respond, if I may, to all of them in one go. And they're the same follow-up questions as were already explored earlier this morning with one. So the first is, should insulting be removed from the bill, so that with regard to the stirring up offences, we are seeking to criminalise only that which is threatening and abusive? Not only for the other characteristics, but also for race. So the first question is, should insulting be removed from the bill? Second question is, does abusive need to be defined to ensure that it is objective rather than subjective? In other words, does before the Crown can show that something is abusive, does the Crown need to show that that behaviour would have caused a reasonable person fear or alarm? And the third question is, should there be a dwelling defence in the bill, as there is in the Public Order Act, or are you relaxed that about the idea of public order offences being committed in a private dwelling? Are you relaxed about that coming within the scope of the criminal law? So a question about insulting, a question about abusive, and a question about the dwelling defence to each of you. And perhaps we'll just take them in the same order with Gary Ritchie first, if I may, please.
Yes, thank you, Chair. I think as both Callum and Anthony had referred to previously, the simple answer to the first question is, from our point of view, yes. Again, because it creates that hierarchy, potentially a discrimination, and secondly, I think because it's inconsistent. It makes it more difficult in terms of officers understanding what types of behaviour and what circumstances actually cross the criminal threshold. There could be circumstances where they're dealing with more than one type of discrimination at the same time, which would further add to the confusion. So yes, your first question. In terms of the second question, abusive behaviour, I think, is pretty common parlance for police officers in the execution of their duty. And while we'd always welcome further clarification, I think should the provisions of the bill remain as they are at the moment, then police officers wouldn't have difficulty in interpreting and applying that legislation as it stands at the moment. The third point, and again, we're probably getting into areas of personal opinion here. I think it would be the organisation's position that some of the offences, potential offences that we're talking about here are so insidious, really, that but for someone to consider, or for the public expectation to be that someone would be considered to be protected just because they commit them in their own home, I think goes a bit too far. And again, I would refer you to some of the answers that were given this morning in respect to the crimes that can be committed within your own home. It's not an unusual thing to see that a crime of such significance wouldn't carry a dwelling defence. And in my view, and I think the view of the police service would be that shouldn't apply in this.
Thank you very much. That's very clear and helpful. Callum Steele, please.
I mean, should insulting be removed? I think the short answer to that is yes. The reasons that were given previously about it's a hangover from the Section 18 of the Public Order Act, I think was well made previous, and there's little that I can add to that. Thereafter, I suppose the question on whether abusive should be an objective or a subjective test is arguably one for the criminal. One for the criminal law to determine. Of course, the fact that there has been debate and discussion on this particular point, I suppose, gets to the very heart of one of the remaining challenges for police officers. We currently, I think, very correctly identify that I think it's the Section 38 of the 2010, what we, in loose parlance refer to as the statutory breach of the peace, provides that objective test for the reasonable person. And in many instances, I think that objective test against things that are immutable and plain to see is very easily applied. I'm not so sure that that same objectivity could be applied, for example, to things that are much more opinion held. For example, religion being the very obvious illustration there, and of course we have areas of sex and gender where in some people's views sex is immutable and gender seems to be much more fluid, but others take the view that rather than being opinions or views that people hold passionately, are in fact immutable in their own right. So I think, like the previous witnesses, I think it would probably be helpful if that objective test was to be written into the legislation, because whilst the current test for objectivity relates to threatening, abusive behaviour or indeed insulting behaviour, I think we have to recognise that there are areas of discourse in Scotland right now, whether it's sexual orientation, whether it's gender recognition, where things that are insulting could very quickly be redefined as abusive in order to hit the criminal threshold in terms of the legislation. And without that reasonable person test, then I think it would make it much harder for those accused of crimes to put forward a defence. I don't think in any way, shape or form it's going to make the policing of it any easier. Simply the removal of insulting in any event does not apply to sexual orientation, transgender identity. But I think it's inevitable that as these kind of crimes become more known across our society, that there is a clamour for the police reach to go much further than perhaps the original statute intended. And finally, about the dwelling defence, I suppose to some extent I I largely concur again with the three learned gentlemen that were on before. There is no general defence for committing crime in your own home in any event. The follow-over from the Public Order Act, I think, is highly relevant, but the removal of the insulting provision, I suppose to some extent, would ameliorate the dwelling defence as a requirement or a perceived requirement. But again, we have to recognise that there are some fairly hot topics that can be discussed in homes that could then find themselves being repeated in public. That, depending on the particular cause or case that was being advocated by others, could then be deemed to be a form of hate crime being taken place in home. And very obviously, the one that presents itself front and centre at this moment in time in Scotland is transgender identity, a conversation that's taking place in a home in respect of that's repeated in the playground. My mum or my dad said, and it's then repeated to further parents who hold a different view. Whilst that, I think, at a conceptual level would be insulting, I don't think it would be too much of a stretch for people to argue that is hateful and abusive. Used to be discussing in the home. So I don't think it's so much in terms of the more, and I'm mindful of how I use this terminology, I don't think it's the more extreme or the more obvious forms of hate crime that the SPF has some concerns with here. It's about those areas that very much fall into the areas of grey, sexual orientation, transgender identity, most obviously at this particular point in time. But again, it's not beyond the realms of possibility that legitimate discussions over immigration status, refugees, that could be taking place in the home could similarly find themselves being reported to the police as hate crimes, simply because conversations that were had in private are taken out of the home, repeated possibly rather innocently by other members of the home, and an abusive label is attached to that.
Absolutely. I think bearing in mind what I call the iron law of unintended consequences is exactly what I'm struggling with here. That's very helpful. Thank you very much. Same questions, please, finally, to Anthony McGeehan.
Thank you, Convener. The proposal to remove the word insulting was reflected in Lord Brackadale's review, and in making that recommendation, Lord Brackadale referred to a review conducted by the Crown Prosecution Service of relevant offences reported to the CPS, and a conclusion that the removal of the word insulting did not reduce their ability to take prosecutorial action against or in relation to reported offences. COPFS has not seen the same scale of relevant offences reported to it during the debate or recently in relation to the 1986 Act, but between April 2009 and March 2020, there are 27 charges reported under Section 18 of the 1986 Act to COPFS and 13 charges under Section 19 of the 1986 Act. Policy officials have conducted a review of those cases, and that review has confirmed that the removal of the word insulting would not diminish the ability of the Crown to take appropriate prosecutorial action in relation to those reported offences, and therefore the Crown would, or the COPFS would support the removal of insulting, and would observe that the removal of insulting would reduce the gap between the approaches taken in relation to race and the remaining protected characteristics. In relation to your second question, which was whether or not there should be a definition of abusive contained within the legislation, the concepts of threatening and abusive behaviour are very familiar concepts in Scots law, very familiar concepts to Scottish prosecutors. But if there were concern that the term abusive was not sufficiently clear, or perhaps risked a subjective assessment of behaviour, then there are precedents for defining abusive behaviour, not only in relation to Section 38 of the 2010 Act, which has been referred to recently during today's sessions, but also in relation to the Domestic Abuse Scotland Act 2018, which introduced a definition of abusive behaviour. So again, the introduction of that definition, it would not be a proposal that COPFS would object to in principle. Finally, your question in relation to the absence of a dwelling defence. Unfortunately, the reality of offences reported to COPFS today is that offences occur within domestic settings. Unfortunately, hate crime occurs within domestic settings. And the absence of a dwelling offence in that context, the wider context of Scots criminal law, I would suggest is not remarkable.
Okay, thank you very much. Those are very crisp, clear and helpful answers from all three of you. I'm very grateful. And I'm going to bring in Liam MacArthur next, and after Liam MacArthur, it'll be Liam Kerr.
Thanks very much, Convener. Good afternoon to the witnesses. I'll maybe start with the issue around freedom of expression. You will have seen from the previous session that I think there was a general feeling that ECHR provisions provide those protections already, but an acknowledgement that while the bill allows for more specific freedom of expression protections in relation to a couple of characteristics, it doesn't do so across the board. The Cabinet Secretary made clear to the committee that he's open to a widening and a deepening of those protections. I was just wondering what the panel's views on that were. Maybe start with Mr McGeehan on that question.
Thank you. The question as to whether or not the provisions in relation to freedom of expression should be broadened or deepened is a matter for the Parliament, but what I can confirm is that at present, prosecutors, when assessing relevant cases, are cognisant of Article 10 rights and would consider any case reported to COPFS with reference to the right to freedom of expression, albeit that the right to freedom of expression is not an unqualified one. And going forward, should the Parliament decide to broaden or deepen the provisions in relation to freedom of expression, those provisions would be reflected in prosecutorial guidance and continue to be reflected in prosecutorial decision making.
That's helpful. I mean, I think the concern, I suppose, that was being raised in terms of the way that things are expressed at present is that it could be construed as something of a hierarchy in terms of where those freedom of expression protections apply. There was also the concern that if you embark on a non-exhaustive list of protections, then there is again always the risk that you're not including some protections that some groups may wish to see. Just from a Crown Office perspective, are those risks that you think can be managed with the Parliament to go down the route of taking up the Cabinet Secretary's offer?
Well, the observation I would offer is that regardless of the approach taken by Parliament, Article 10 would apply to prosecutorial decision making, and prosecutors will have obvious regard to the terms of the legislation, but today and tomorrow would have regard to Article 10 rights for persons accused of these crimes and reported to COPFS.
Okay, thank you. Can I maybe turn to ACC Ritchie and then to Callum Steele if they've got any observations in this area?
Yeah, again, my observations are similar to Anthony's there. I think it's to be welcomed. It's a matter for, of course, for the Parliament to the extent in which they define that. We are again well used to policing and ensuring that in the manner that we police. Just for an example, with the Public Order Act, that we ensure that those Article 10 protections are actually built into our policing plans and our policing responses. It's helpful, I think, for police officers to have that freedom of expression provision in there, and as I say, it's a matter for the Parliament as to how extensive that is.
You talked earlier about the benefits of the additional clarity, so it may be as much for those that police are engaging with as it is about the police's understanding, as you say, of perhaps offences they're well used to dealing with. That a non-exhaustive list might actually be quite helpful. Is that the case?
It's always more helpful to us in terms of policing if the people that we're policing understand the legislation. And when I said that it's helpful to police officers, that's actually what I meant. If it's laid out in clear terms as to what's permitted and what's not, then that is helpful. Just purely in terms of our engagement with people.
Thanks so much. Callum Steele, you got any comments on this area?
Yes, and through yourself, Convener. I suppose to some extent this is where the difference between the law at the prosecution stage versus the law at the application stage, where the police tend to clash. I think the comments that were made previously, I think most strongly by Mr. Dunlop, that it would almost be impossible for prosecutions to take place against the backdrop of Article 10 rights, even where there is not an expressive or an exhaustive list contained on the face of the Act that would provide freedom of expression defences. But set against that, we have the very real situation where, if it is not written on the face of the Act, the absence of an express freedom of expression provision will be utilised as a vehicle to levy criticism at the police service for not acting on concerns that certain kinds of behaviour may fall into being perceived by certain groups as being threatening or abusive. And I do think that to some extent this is where we have to pay much more attention to the potential impact on the relationship between the public and the police service. To some extent, the police always have to make a value judgment as to whether the activity that they are policing is in its own right likely to be found criminal by the courts. But again, and I don't want to labour the particular point about transgender identity, but that is one which very clearly has the potential to result in fairly significant comment by a whole load of people, result in fairly significant expectations on the police service to undertake certain acts and actions in response to it, result in adversarial contact between the police and members of the public, and probably not result in a prosecution because of the Article 10 provisions. So, extending a list would be helpful from a policing perspective, if not particularly informative from a prosecutorial perspective.
That's very helpful. Thanks very much, Callum. Thanks, Convener.
Thank you. So I'm going to bring in Liam Kerr next, and then after Liam Kerr, it'll be Shona Robertson, please. Liam.
Thank you, Convener. Just one brief question from me, which I'll direct to ACC Ritchie, then Callum Steele, then Anthony McGeehan, if I may. You heard, gentlemen, in the first panel that there are concerns in Section 6 around search and seize, particularly over the precision of the drafting and the definitions around what might be seized. And I also note, Callum Steele, you raised an issue about the extension to police staff in your earlier comments. So the question, in the order that I've suggested we might answer them, is: do you share these concerns? And if so, what needs to change in Section 6 to address them? ACC Ritchie.
It seems in my reading that Section 6 provides a fairly traditional and, I suppose, power of search, what you would normally see, and it's a warranted power of search as well. So in actual fact, police officers need to ensure that the evidence is compelling enough or convincing enough to take to a sheriff or justice of the peace in order to get a warrant in the first place. So I think the point that was made earlier about there being malicious reports that could lead us to taking some type of positive interventionary action that's going to involve us crashing down the door. Context. Receiving, I think, for example, one anonymous phone call that somebody may have materials that cross over into the realms of being an offence. would be insufficient for us to even approach a sheriff or a GP and look for a warrant. So in that respect, I think in the practical sense, as I've said before, I need to keep speaking in the practical sense. I don't really have an issue with the power of search as it's framed. And moving on to Callum's point before about members of police staff, which is the unusual element of this, I think from my point of view, the intention behind that legislation is probably to recognise the fact that we may have recruited experts in terms of forensic analysis, cyber analysis, etc., for various elements of policing, and in the future we might see much more of that investigative capability not being in the hands of police officers. So it's perhaps a nod to the future, but it is something that I think is probably worth a bit more exploration.
Alan Steele?
Again, through yourself, convener. I don't want to sound like a scratch record, but I believe that the removal of the likely provisions to some extent significantly ameliorate concerns that surrounded Section 6 of the legislation. Of course, like all of these things, ultimately case law will be the determining factor as to whether the provisions are being correctly used or whether they're not. But I do think that the concerns that were raised or identified by Messrs Dunlop, Clancy and Tickell in the earlier session probably give a much rounder answer in terms of relevance than anything the SPF could offer in that regard. I mean, ultimately, we will always be, as police officers, do what we believe the law allows us to do, and if ultimately case law finds against us, then practice is moderated accordingly thereafter.
Very grateful.
Sorry, Mr. Kerr, just before I leave that, I do again want to come back to the issue of the investigative powers and the role of police staff. There are many things just now that police officers don't have the skills for, or indeed the technology to be able to be performed, but the use of invasive powers in their own right still tend to be reserved to police officers. Invasive and coercive powers are reserved to police officers, even if the investigative capacity rests somewhere else within the police service. And I can't envisage any occasion where a non-warranted individual would be metaphorically going through a door and seizing equipment from members of the public. Let us not forget that members of police staff are not curtailed from taking active parts in politics. They're not curtailed from taking active part in public and political debate. And again, to reiterate the point that in our written submission, it's entirely possible that through those freedoms that they enjoy as effectively members of the public working in the police service, that they could then find themselves using coercive and enforcement powers on members of the public for the investigation of offences that they themselves have taken very public positions on. And I don't think that's a very helpful wedge to introduce into the role of police officers in society, or who has enforcement or coercive powers over the public.
Thank you for that. Anthony McGeehan, have you anything to add?
Maybe as a result of setting the concerns that remain in a real-world context. As Mr Steele has said, a number of the concerns that were raised have been mitigated by the proposed amendment by the Scottish Government. But in relation to those remaining concerns, if I could set those in a real-world warrant situation, as Mr Ritchie has already indicated, the police would only approach or consider an application for a warrant where the police officers involved thought it was a proportionate response to the alleged offence. The police would not seek a warrant directly from a justice of the peace or sheriff, but would rather apply to a procurator fiscal to make an assessment as to whether or not there were reasonable grounds to approach a GP or sheriff for a warrant. Finally, the sheriff would have to make an assessment as to whether or not the granting of a search warrant was an appropriate and proportionate response to the alleged offence. So whilst there are concerns Some of those concerns are mitigated by the systemic approach to the consideration and granting of a warrant. In relation to the issue raised by Mr Steele in relation to the granting of a warrant to a member of police staff, again, if I could set that in a real-world context, it is not unusual for a Procurator Fiscal to be approached for a warrant in relation to material that is held electronically, and for the requesting police officer to advise that in order to effectively execute the search warrant, they will require the assistance of forensic experts. And it would not be unusual for a Procurator Fiscal to seek a search warrant that allowed a uniformed police officer to execute a search warrant with the assistance of other members of police staff, as distinct from a search warrant being executed distinctly by a member of police staff who is not a police constable. So that may therefore be a concern that could be addressed through the tightening up of the drafting of this particular section. Finally, in relation to one of the concerns that was raised this morning, which was in relation to the lack of a time limit attached to search warrants granted under this section, there are statutes that grant or that impose a time limit in relation to search warrants, such as under the Misuse of Drugs Act, but there are also search warrants under statutes that don't have a time limit attached to them, and the vast majority of common law warrants granted in Scotland do not have any time limit attached to them, and therefore the fact that there is not a time limit attached to this particular proposed warrant provision is not remarkable. But if the Parliament were to decide that a time limit should be attached to this warrant provision, from a practical perspective, subject to anything that Callum and Gary may offer, I don't think that would cause a practical problem.
Okay, thank you. I don't know if either Callum or Gary want to come back on that final point, but if they don't, then we will move on to Shona Robertson, please, who has questions about the statutory aggravation. Shona. So, sorry, Shona, you're still on mute. Could somebody unmute Shona Robertson's microphone, please? Thank you.
Thank you, Convener. I'll wrap two questions into one for the sake of time. Lord Brackadale recommended that statutory aggravations should continue to be the core method of prosecuting hate crime in Scotland. Want to ask the panel whether they agree with that and whether the bill effectively provides for that. But added to that, in line with existing legislation, the bill states that the court must make clear what difference an aggravation has made to the sentence imposed. Now, look, you might be aware Lord Brackadale recommended removing this requirement. I think he felt that the practicalities of pulling out that element of sentencing would be quite challenging. So it would be helpful to also hear from the panel whether the retention of this requirement is helpful or not. Maybe Mr. McGeehan first, please.
Certainly, dealing with those two questions in turn, I would confirm that the bill does make effective provision for the continued approach of addressing hate crime by way of statutory aggravations. That is a well-established approach in Scotland, familiar to both police and prosecutors, and it is an approach that it is not limited to hate crime. So, for example, a similar approach is adopted in relation to domestic abuse. So the continuation of this approach and its articulation as set out in the bill is one that COPFS would support. In relation to your second question, which is in relation to the court making clear at sentencing the proportion of the sentence that attaches to the aggravated nature of the offence, COPFS are not best placed to offer comment on that, and I would suggest that those best placed to offer comment on the practicalities of that process would be members of the judiciary, and I know that judicial representatives have provided written evidence to the committee in that regard, but I presume that it would also be useful to the committee to hear from victims' representatives who would perhaps be better able to offer an alternative perspective on the value that victims perhaps receive as a result of that approach.
Yes, thanks for that. I mean, obviously the argument in favour is around increasing transparency so that victims can see the element of aggravation, but it's whether in practice that is feasible. Would any of the rest of the panel like to comment on that? Yeah, Mr. Ritchie.
Just very briefly to say that, yeah, I agree with what Anthony just said there, and from a policeman perspective, we are well used to actually dealing with the statutory aggravators. It makes it easier for police officers, again, to understand. It will make the training and communication of the new provisions easier for us. And again, in relation to the second question, I suppose it's not for me to comment at all on the actual sentencing provisions. It will undoubtedly require officers to provide information. We just spoke about victims there, for example. More information perhaps in the police reporting stage, but in actual fact I would see that as probably increasing public confidence in our actions, so no issues with that at all.
Okay, thank you. Mr. Steele, do you have anything to add?
Thank you again for yourself, Convener. I think just for the sake of brevity, I agree entirely with what Mr. McGeechan said.
Great, thanks. That's all from me, Convener.
Thank you very much, Shona. That's very helpful. I think John Finney has some questions in this area as well. And then after John, it'll be Rona Mackay, please. John.
Thank you very much, Convener. And it's a question for the panel, following on from what Shona's just asked there, because I note in evidence, Mr. Steele, for instance, commends their approach of the sentencing judge stating the background. Can I ask particularly to the police officers about the implications of recording that information for police operations? Would that have an impact on how subsequent investigations might take place, or is it just interesting to know? So the requirement to retain information on criminal records about the aggravator. Perhaps Mr. Rich.
Thanks, Mr. Finney. I would just reiterate that we're well used to actually dealing with statutory aggravations in terms of the reporting of crime, and we capture that information just now. So I don't see, just to keep it brief, I don't really see that being problematic in terms of our recording or our usage of that information.
Okay, thank you very much. A further question, if I may, Convener, and it's one I posed to the previous panel. It's about a recommendation that Lord Bracadale had about repealing the offence of racially aggravated harassment. Now, that's not a position that the Scottish Government accepted. So can I ask the panel their views on that? Whether, I noted earlier, I think Mr. Ritchie used the term equivalence. Clearly, there's a difference. This is consolidating legislation. Do you think this is creating a hierarchy among the protected characteristics, please?
Thanks again, Mr. Finney. I think that, yeah, you're right. The comment I made before about the consolidation creating an equivalence is something that's going to provide. It's going to make it easier, I think, for police officers to understand hate crime as a whole and what's acceptable and what's unacceptable. So I recognise the recommendation and the actions of the Scottish Parliament, but I think that consolidation broadly would be welcomed in respect of policing, and also I think in shaping public understanding of what's acceptable and what's unacceptable behaviour.
Sorry, can I maybe just push you a little bit, Mr. Ritchie? Notwithstanding that difference being there, of that aggravation being applicable to only one of the characteristics.
I think, yes, I mean, there is a danger of that hierarchy, as I say. So that would potentially exist to cause a bit of uncertainty if that hierarchy existed. There's no doubt about that. And that's why I think we would always support, as I say, any piece of legislation which seeks to consolidate and create equivalence across a broad definition of what hate crime is.
Okay, thank you very much for that. I don't know, Mr. Steele or Mr. McGeechan, if you wish to comment on that matter at all, please. Yes, Mr. Steele.
Yes, again, through yourself, Convener. I suppose to some extent this comes down to the question as to whether it would be an offence libelled in its own right, the retained offence, or whether it would be libelled as an alternative to the new offence falling under Section 3.1. You know, the way the offence is currently drafted, I see that the alternative would always be libelled as an alternative, and as such, and in line with the comments that were made by the previous witnesses, I'm not entirely sure what is gained by its retention. You know, consolidation and simplification of legislation should be just that. You know, and you know, the very learned gentleman in session before me that I think made the point very convincingly.
Okay, thank you very much indeed. Mr. McGeechan, I understand you wish to comment. Thank you.
Thank you, Mr. Finney. The hate crime in Scotland has evolved over a number of years, and that evolution is reflected in hate crime being found in a variety of different statutes, with titles for those statutes that often do not indicate immediately to the reader that they relate to hate crime. This legislation is an opportunity to consolidate hate crime in a single place with an easily understood title and an easily understood reference point for the public, police, prosecutors and the courts. To leave Section 50A outstanding leaves Section 50A as an outlier in relation to that approach, and arguably inconsistent with that approach of consolidation of all relevant hate crime law in a single place. Lord Bracadale's recommended the repeal of Section 50A, and in making that recommendation he observed that the repeal of Section 50A would not diminish the ability of police or prosecutors to respond to racial hate crime, and that is the experience of COPFS. If we look at offences that are reported as Section 50A, those offences can be libelled as a contravention of Section 38 of the 2010 Act with an aggravation, and therefore the position of COPFS is that a repeal of Section 50 would not diminish our ability to respond to racial hate crime.
Okay, many thanks indeed. Thank you, panel. That's me, Convener. Thank you.
Thank you very much, John. I'm going to move straight to Rona Mackay next, please. Rona.
Thank you, Convener. Yes, I'll be very brief here. It's sort of following on from those questions. Can I go, please, to Anthony McGeechan first, please? You'd said earlier that you didn't think that removing insulting from the bill with regard to racial hatred would diminish the ability to prosecute. Given that 2/3 of hate crime relate to race, would you agree that perhaps there is a danger about the perception, public perception, that if insulting is removed, then people might say, well, it's okay, I can say what I like because I'm not going to be prosecuted. I was only insulting them. So is there not a danger that it swings too far if you take that out?
If there is a risk, I would suggest that risk would be mitigated by securing public confidence through effectively responding to hate crime. And the analysis by COPFS is that the removal of insulting would not diminish our ability to effectively respond to racial hate crime. I would also suggest that there is a consequential and different risk of the retention of insulting in relation to racial hate crime, and that is that there is understood to be a difference in the behaviour that is allowed in relation to the other protected characteristics, but not in relation to race crime. And I think that would be a legitimate expectation should Parliament choose to describe different types of hate crime as criminal in different ways. and therefore I would suggest that whilst the risk that you've identified, it may be a real one, I would suggest that can be effectively addressed through the continuing effective prosecution of hate crime with an amended piece of legislation.
Thank you. I'm not sure if Callum Steele or Gary would like to come in.
They're both saying no, Rona.
Okay, that's fine. Thank you, convener.
In that case, thank you very much. We're going to move now to other hate crime characteristics, including sex and misogynistic harassment. And I think Fulton McGregor first, followed by Annabel Ewing. Fulton.
Thank you, convener, and it's good afternoon now. Good afternoon, panel. I don't know if you've seen the previous session, but I'm going to ask the same questions as asked to this morning's panel. And again, just like last time, I'll ask them both together, if that's okay. So we've had some suggestions for adding proposed hate crime characteristics to include gypsy travellers, asylum seekers and refugees. To what extent do you think that they're already covered by the characteristic of race? Do you think there's any merit in adding these characteristics? And then also on the issue of sectarianism, there isn't any specific provision to deal with this. Again, do you think that the hate crime characteristics of race and religion cover this, or do you think there should have been a specific provision for sectarianism? And again, convener, I'm happy for any order. So we could start with Callum Steele.
Thank you, convener, and also thank you, Mr. McGregor. I don't genuinely think that anything I can contribute in terms of the additional classifications would trump the comments and observations that were made in the previous panel. If people in the legal profession are content that the legislation as drafted would effectively cover asylum seekers or gypsy travellers, then I would have to bow to my superior knowledge on that issue. I suppose the question of I suppose that the question then of sectarianism becomes one which is much more tricky, I suppose, because I suppose implicit in the question is the suggestion as to whether the activities that are currently taking place, as opposed to some extent in football grounds, would fall to be covered by the legislation as drafted. And I think to some extent this is more a policy question rather than a legislation question. I'm fairly comfortable that the law as drafted would cover certainly threatening, abusive behaviour in a religious or sectarian sense that's taking place in environments such as football stadia. The question is whether there is a policy appetite for the police service to police that, in a very, I suppose, a very officious manner, with large numbers of individuals almost certainly facing criminal prosecution as a consequence, compared to dealing with individual examples of sectarian behaviour that may take place in much smaller environments. So, legislatively, I think the legislation as drafted almost certainly adequately covers the question of sectarianism from a legal perspective. But I suppose and in fact, no suppose about it, the absolute challenge is the appetite for the policing of what would be criminal behaviour in certain environments, simply because of the other challenges it creates from a policing perspective.
Okay, thanks very much for that, Mr. Steele. Anthony McGeehan.
Okay. Thank you, Mr. McGregor. Taking your two questions in turn, in relation to the question as to whether or not hate crimes directed at refugees, asylum seekers or gypsy travellers would be captured under the current proposed bill, my assessment is that such offences would be captured under the current bill, with the expanded definition of race described at section 1.2 of the bill, which captures not only race but also colour, nationality, including citizenship or ethnic or national origins. Obviously, each case would be dependent upon its own facts and circumstances, but broadly speaking, the categories of victims that you have described would be protected under the terms of the bill. Moving to your second question as to whether or not there should be a separate statutory aggravation in relation to sectarianism, ultimately that would be a policy decision for the Scottish Parliament, but the committee will be aware that Lord Brackadale's assessment is that the current statutory aggravations in relation to both race and religion are sufficient to address behaviours broadly understood to be sectarian in their nature, and that is an assessment with which COPFS would agree. The other observation I would offer is that should such an aggravation be introduced from an operational perspective, what would be necessary would be a clear understanding of the interaction of that additional statutory aggravation with the presumably pre-existing statutory aggravations of race and religion.
Okay, thanks again for that. ACC, Gary Ritchie.
Yes, thanks, Mr McGregor. I don't really have much to add. I don't think there's a gap in the legislation in terms of sectarianism or in terms of race here, but of course it's a matter for the Parliament. Just on that point, I don't think whether it's defined as sectarianism or maintained under the provisions of the Act at the moment is really going to have any material impact in the appetite for policing and providing a policing response in respect to behaviour that we see anywhere.
Okay, thanks, Convener. I think they were all pretty clear, concise and consistent answers, so thanks for that.
Thank you very much, Fulton. And the last questions in this area are from Annabel Ewing, and then after Annabel Ewing, it'll be James Kelly to wrap up. Annabel, please.
Thank you, Convener. Good afternoon to our panel. My question, I think, would be directed to Mr McGeechan, but obviously if the other witnesses wish to chip in, absolutely please do so, and for the purposes of broadcasting, if they do wish to chip in, it would be first perhaps Callum Steele and then the Assistant Chief Constable. Turning to the issue of the non-inclusion of the characteristic of sex in the bill as it is currently drafted, with this in tandem development of policy through this working group on misogynistic harassment, it would be interesting to hear from COPFS if they feel that, because this is likely to take some time, and the parliamentary session is expiring next March, when hopefully we will have some bill passed by the Parliament. Does Ms McGeechan feel that there would be any gap then, both in terms of the issue of the characteristic of sex and in terms of the issue of misogynistic harassment? I have noted in some of the written submissions that some are of the view, at any rate, that actually existing current statutory offences would be sufficient to cover misogynistic harassment. But now that we've got the expert here, it would be interesting to hear what Mr McGeechan has to say.
Well, firstly, for the record, I'll take exception to being described as the expert in this area. The observation I would offer is that the statutory aggravation model, by definition, proceeds on the basis that there is an existing foundation offence. So the absence of an aggravation in relation to gender at this time does not prevent COPFS taking prosecutorial action in relation to cases that are reported at present. And the addition of the statutory aggravation in relation to gender would not aid our ability to address offences reported to COPFS. In relation to the wider, that observation is offered recognising that Lord Brackadale recommended the addition of an aggravation in relation to gender or sex. The observation I would offer would be to echo my observation in relation to the potential for an aggravation in relation to sectarianism. I would suggest that from an operational perspective, it would be necessary for there to be a clear understanding of and a clear decision in relation to the potential interaction of an additional aggravation in relation to gender, and the potential freestanding offence, new offence in relation to misogyny, and the foundation offences to which those aggravations or which most commonly potentially feature evidence of misogyny, and the interaction of those three things. Firstly, the aggravation of gender. Secondly, the potential for a new crime of misogyny or something similar. And finally, the foundation offences to which those conditions would normally attach.
I thank Ms McGeehan for that answer. I mean, obviously, again, interestingly, further work for us to do as a committee in reflecting upon that. I would just make the point, of course, that we wouldn't want to conflate, presumably, sex with gender. Sex is the protected characteristic, and I think Lord Brackadale made a sort of indirect reference to that in his testimony last week. I'm not sure if either of the other gentlemen wish to chip in. I'm not seeing. Thank you, and thank you, Convener.
Thank you very much, Annabel. So, James Kelly, I think the final questions for this panel will be from you. Thank you.
Thank you, Convener, and good afternoon, panel. If I can turn first of all to the police representatives, Mr. Steele first and then Mr. Ritchie. Can I ask, how do you feel that the passing of this legislation will it significantly impact on a call on police resources? And do you feel that the Bill's financial memorandum adequately reflects that? Mr. Steele first.
I think, Convener, with the modifications that have been suggested, and ultimately, of course, you've got to see what the final bill as passed will look like, that a large proportion of the concerns of the likely costs on policing and police training time have been significantly addressed. That being said, as I alluded to earlier on, it is inevitable that when new legislation is created, that the requirement to measure, to record, to report on that legislation and the circumstances surrounding it creates a fairly hefty administrative burden on the police service. So whilst it's unlikely to change the approach to policing per se, it is going to place, in our considered view, very weighty costs on the police service, and certainly the financial memorandum comes nowhere close to being able to adequately describe that. I very much regret that we've not been able to have the opportunity to sit down with the service, just through no fault of anyone's other than time and additional pressures, to be able to properly quantify what those costs are likely to be. But certainly experience going back over the guts of a decade and a half tends to suggest to me that anything that is associated with cost when it comes to police technology and recording system tends to be grossly underestimated by the parliamentary authorities.
Thank you. Mr. Ritchie.
Thanks, Mr. Kelly. I'll make a few points. Again, we really, for us to get to an accurate assessment, we really need to know what the provisions of the final bill actually look like, because that will allow us to make an estimation, an accurate estimation of just the extent of training that we need. If we're talking about, for example, statutory aggravations, then potentially that training could be done online. If we're talking about, for example, using different terms like insulting behaviour, then perhaps it's going to have to be more extensive, etc. So we do need to wait to see that. And in respect to the technology and recording, we are developing systems at the moment that are going to be far more flexible. Again, as Callum rightly says, the costs are unknown, but it's not necessary that since we're developing systems now that they might be significant. Again, we have to wait and see. I think the most important point on about demand to make here is that we know that hate crime is underreported. And we are trying, it's our policy to try and do what we can to increase the amount of reporting the hate crime. I think having a bill which is easier to understand, where the offences are consolidated, where the public knowledge of what constitutes acceptable and unacceptable behaviour in the eyes of the law is all to be welcomed, and I hope that in a way that does increase demand. That will, of course, bring costs, but with the intention of the bill and the intention, I'm sure, of this panel is to have a real impact in hate crime in this country, that will raise attendant demands with the police, but that's what we've been looking for a number of years now.
Okay, thanks for those answers. Just turning to Mr Mageehan, from the point of view of the Crown Office and Procurator Fiscal Service, we heard last week from the ACT Committee that the Scottish Court Service had some anxiety about not having adequate sight of the financial memorandum. What's your view in terms of resources and the financial memorandum as drafted?
The Scottish Government engaged with COPFS in relation to likely costs resulting from this bill. The principal cost identified, Mr Kelly, was in relation to the cost of training and revised guidance for prosecutors, and the cost that was attached to that work was £50,000. And our assessment is that is a reasonable estimate of the cost that would immediately result from the bill. There is a potential future cost in relation to new offences that may result. The financial memorandum does not anticipate significant numbers of new offences being reported, and subject to the very important caveat that Mr Ritchie has just raised there. Again, I think that the approach of the Scottish Government's financial memorandum is a reasonable one. The reason I say that is that in relation to the preceding offences under the Public Order Act 1986, there have been very limited numbers of offences reported to COPFS. In relation to the broadly analogous offences in relation to religious prejudice created under the Offensive Behaviour at Football Act, again, there were limited numbers of offences reported in connection with that Act. And then finally, as recognised by Lord Brackadale, a number of the stirring up offences would not be new offences, in inverted commas, but would rather be a different articulation of existing criminal offences. So I think that the approach taken in the financial memorandum is a reasonable one. We would obviously monitor the subsequent rates of offences reported to COPFS and engage with the Scottish Government should those numbers rise significantly. And I would return to the caveat that Mr Ritchie has offered, and that is that increasing numbers of hate crimes being reported would may be a reflection of increased public confidence in the reporting of those offences and an appropriate response of the state to those offences, and that would be no bad thing.
Okay, thanks for that. That's all from me, Convener.
Thank you very much, James, and thank you for those answers. Indeed, thank you for all of your time and thoughtful contributions this morning and this afternoon. All three members of the panel have really helped the committee with our work on this bill, and we're very grateful to you. Thank you very much. But we're going to move directly on. We've got two more, hopefully quick, items of public business today. The next item of business is consideration of two negative instruments, the Electronic Monitoring Approved Devices Scotland regulations and the Electronic Monitoring Relevant Disposals Scotland regulations. Do committees, these are negative instruments, do committees have any comments on the SSIs, and in particular, do members wish to take up the issue with regard to the question about the vires of the relevant disposals regulations, picking up evidence that was given to the committee by the Law Society of Scotland when the committee considered the Management of Offenders Bill earlier in this session. As I understand it, there is time for us to write, if the committee wants to, to the Minister to obtain the Minister's assurances as to why the Scottish Government's view is that these regulations fall within VARIs. And my personal view is that given that there is the time for us to do that, we probably should do it, given that those concerns were raised to the committee by the Law Society of Scotland last year. Our members agreed. Is anybody unhappy with that? Or in that case, Stephen, I think that's what we will do, and that means, as I understand it, and correct me if I'm wrong, that we don't wish to make any comment with regard to the approved devices regulations, and that we will return to the relevant disposals regulations after we've heard from the Minister. Thank you. And the next item last item of public business is a report back on the meeting last week of the Justice Subcommittee on Policing. And John Finney has indicated to me that he is content for that written report to be taken without him adding to it at the moment, unless he wants to. He's content, but Annabel Ewing would like to say something. Annabel.
Yes, thank you, Convener. Just very briefly, I'm not sure of the etiquette and process here because it's the subcommittee, but I just noticed that in the evidence, whereas the UK Government Minister seemed to indicate that all matters had been duly clarified about Brexit impact, the Police Scotland representative basically said that was news to them and they hadn't been cited on anything. So I think that's a really important issue to seek clarification on, because the issues, the arrest warrant, all the rest of it, are really very important issues for the ongoing administration of justice. So I would be hopeful that we could seek that clarification from the UK Government as a committee. Thank you.
Well, I completely agree that the matters are extremely important, but I would have thought, John Finney will correct me if I'm wrong, but I would have thought that that's a matter for the subcommittee to take up in correspondence with the relevant UK Minister. But John, perhaps you'd like to clarify.
Thank you, Convener. And Annabel makes a very valid point. I think we had a very diplomatic reply from Mr Kerr, the Deputy Chief Constable. It's fair to say that there's ongoing engagement from the subcommittee, which of course acts on the parent committee's behalf on these issues. So that is something that we can follow up on, that specific request.
So, Annabel, are you content for that future yes. correspondence to come from John Finney as convener of the subcommittee on behalf of us all? Thank you very much. That concludes our public business today. Thank you very much. Our next meeting will be on Tuesday, the 10th of November, which, like today, will be a virtual meeting. And when, like today, we will continue to take stage 1 evidence on the hate crime bill. I now close the public part of this meeting, and members should please disconnect from BlueJeans and join us on Microsoft Teams. Thank you very much.